Good afternoon, and welcome to the Appellate Division First Department 2.0. Obviously, we thought that we were past virtual oral arguments, but COVID had other ideas. So what I'll do is, as you were previously instructed, I will call the calendar and indicate the time that has been allocated to each appeal. First case on the calendar is People versus Elvis Sanchez. Appellant has been allocated 5 minutes and one in rebuttal. The people get 5 minutes. Curtis versus Marino. Appellant Curtis gets 6 minutes and one in rebuttal. Respondent Marino gets 6 minutes. Melissa versus Damien is submitted. Lara versus Kadir. Appellant Kadir is allocated 5 minutes and one in rebuttal. Lara gets 4 minutes. Salcedo versus City of New York. Appellant Salcedo gets 4 minutes and one in rebuttal. City of New York gets 4 minutes. People versus Wilson. Wilson is allocated 3 minutes and one in rebuttal. The people get 3 minutes. 150 East 3rd Street versus Ryan. Petitioner 150 East 3rd Street will get 5 minutes and one in rebuttal. The respondent, Ryan, will get 5 minutes. Although I have called that case in order, that case will be heard last. One of our justices will be recused, and I don't want that justice to log off and not be able to log back on. So although I called it now, that call will be heard last. Next case on the calendar is Sharma versus Walia. Appellant Sharman is given 6 minutes and one in rebuttal. Walia gets 6 minutes. People versus Bing. Appellant Bing gets 3 minutes and one in rebuttal. The people get 3 minutes. Lewis versus 311 Realty. Appellant 311 Realty is given 5 minutes and one in rebuttal. Respondent Lewis gets 5 minutes. People versus Hickman. Appellant Hickman gets 5 minutes and one in rebuttal. The people get 5 minutes. Favorite Limited versus Chico. Appellant Chico gets 5 minutes and one in rebuttal. Favorite Limited gets 5 minutes. People versus Monegro is submitted. Rodriguez versus Morel. Assuming that all the parties show up when I call it again, Appellant Rodriguez gets 4 minutes and one in rebuttal. Respondent Morel gets 4 minutes. Summit Restaurant versus New York City DOE. Appellant Summit Restaurant gets 5 minutes and one in rebuttal. New York City Department of Education gets 5 minutes. Resnick Seaport versus Xenopolis. Resnick Seaport appellant gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. Durazno v. 685th Avenue. Appellant Durazno gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. Gross versus Hassan Gross is submitted. So the first case on the calendar is People versus Sanchez.
Good afternoon, Your Honors. Katrina Jean Myers from the Office of the Appellate for Elvis Sanchez. May I begin?
You may begin.
Thank you. Mr. Sanchez's jury trial waiver was not knowing and voluntary because it was executed after the court told him that he could be found guilty after a non-unanimous verdict. This was not merely one simple misstatement nestled into—
We're in all the part. We're not. It seems that that was an error on the part of the judge. But weren't there all the parts, statements by the court that rectify that error?
No, Judge. The only other statements were the court's expression that there was a right to a jury trial and that the prosecution had to prove guilt beyond a reasonable doubt. Other than that, there was no language in the colloquy to rectify the court's misstatement of the law. Further, the court should have been on further notice that its colloquy needed to be on point to ascertain that Mr. Sanchez's waiver was knowing and voluntary because it was aware of his extensive mental health issues. The prior court had ordered a 7:30 examination of Mr. Sanchez. The court also had record that he was institutionalized while awaiting trial for this case because of suicide attempts and hallucinations. They should have put the court on call to have a heightened colloquy to make sure that he understood the importance of the right that he was waiving. What's more, the trial court deprived defense counsel of the opportunity to make a record of Mr. Sanchez's decisions and the thoughts that were going through his mind at the time. For these reasons,
I'm sorry, this is Justice Molden. Didn't the court basically sum up what defense counsel would have said about his advice to the defendant about not going forward with a non-jury? And then defense counsel ratified what the court said.
The court asked defense counsel if the nature of what he was going to say was about Mr. Sanchez's decision and that it was against counsel's advice. The court then deprived defense counsel of the opportunity to expand on that notion and put
but did defense counsel respond to the court and say, yes, Judge, that's basically what I was going to say, something along those lines?
That's correct, Judge. That's correct. However, we don't know what factual details went into counsel's discussions with Mr. Sanchez and Mr. Sanchez's decision to waive his jury trial rights. That was the breadth of the conversation that defense counsel was not allowed to expand on. And the court's deprivation of that deprived Mr. Sanchez of the opportunity now to rely on the record to discuss more about his knowledge of the right at the time. And considering his—
Sorry to interrupt you again, but couldn't defense counsel had said at some point, Judge, I think you might have misspoke there. We need unanimity of the 12-person jury. Isn't that right, Judge? And then just correct the record right there on the spot.
Correct, Judge. The record here, or the claim here, is unpreserved, and Mr. Sanchez is asking this court to reach a decision in the interest of justice. Here, the court blatantly misstated the standard for a guilty verdict, and there is nothing else in the record to rectify the court's error.
What about all the parts, Ms. Myers? What about all the parts of the transcript where the court clearly states that all 12 juries had to be in agreement?
Yes, Judge, that does provide further knowledge for Mr. Sanchez, but it does not negate the very blatant misstatement of the law that Mr. Sanchez can be found guilty by a non-unanimous jury verdict. Mr. Sanchez affirmed.
You only have a minute, Ms. Myers. Can you address yourself to the sentence?
Yes, Your Honor. Mr. Sanchez is asking for a reduction in his sentence. He is sentenced to an aggregate of 52 years. The nature of his crime is inarguably awful. However, the sentence that he received is a lot greater than individuals who committed similar offenses. For that reason, he is asking the court to reduce his sentence to a term of incarceration that is comparable to other individuals who have committed equally heinous acts. And if I could address his Apprendi issue during rebuttal, that would be appreciated.
That would be great. Thank you. Let me hear from the people.
May it please the court, Alexander Michaels on behalf of the people. May I proceed?
You may.
Thank you. As the court already seems to recognize, the record simply does not support defendant's arguments concerning the jury waiver. That claim is completely unpreserved, and there's no reason to reach it in the interest of justice because the defendant clearly and consistently stated that he wanted to waive his right to a jury, and the court's waiver colloquy actually went above and beyond what the law requires there. To the extent that there appears to have been a transcription error, that error was clearly rectified by the court's statement, and I'll quote, the people would have to prove your guilt beyond a reasonable doubt to all 12 of them. So for those reasons, there's no reason to reach this claim in the interest of justice. As for defendant's complaints about the handling of the predatory sexual assault against a child charges, those are also entirely unpreserved. And again, there's no reason to reach them in the interest of justice because defendant simply cannot have been prejudiced by any of the asserted errors there. Unless the court has any questions, we ask that the court affirm.
I think we're good. Ms. Myers, do you have a minute in rebuttal?
Yes, Judge. Briefly, yes, while the trial court told Mr. Sanchez that the prosecution had the burden to prove his guilt to all 12 jurors, that is not logically inconsistent with its statement that he could be found guilty by a non-unanimous verdict. Those two things don't operate one or the other, or they don't. They're two distinct logical principles that are not in conflict with each other. To move to the Apprendi issue, predatory sexual assault against a child is an A2 felony. First-degree rape is a B felony. The verdict in Mr. Sanchez's case was multiplicitous because he was found guilty of both the A2 and the B charges. In order for the court to reach a constitutional verdict in Mr. Sanchez's case, there needed to be a factual distinction between those two crimes, and there simply wasn't one. The court needed to consider whether or not the B charge and the A2 charge could be considered together because there was a reasonable view of the evidence that Mr. Sanchez's conduct lacked a heinous quality. And that didn't happen here. The result was the court had its pick of two charges with different felony classifications and decided to uphold the A2 count because it had a higher sentencing background. And this violates Apprendi and requires reversal.
Thank you.
Thank you, Judge.
Thank you both. Okay, Curtis V. Marino.
Good afternoon, Your Honors. May it please the court, Meredith Miller on behalf of Plaintiff Appellant. May I proceed?
You may.
Thank you. Your Honors, the decision below should be reversed because it foreclosed plaintiff from pursuing his discrimination claims against his former employer in both court and in arbitration. It essentially leaves plaintiff with no path whatsoever to hold defendants accountable. Fundamentally, the appeal is about how far an employer may overreach using a contract to put obstacles in the way of an employee who has statutory discrimination.
And that seems to have been resolved by that CPLR 7515, is it? So that issue of whether you can reduce the statute of limitations by contract is an issue that has been addressed. But I also agree with you with respect to the procedural unconscionability, the unconscionable circumstances surrounding. I mean, your brief lays it out very well. You have 14 minutes to do about 5 different things, including logging on, reading the documents, and then signing them, which obviously is physically impossible. But what about the substantive unconscionability? Hasn't this court held that it is permissible to allow the parties to, notwithstanding the lack of parity between them, I agree with you, but we have allowed an arbitration provision or a contract that reduces the time for you to file, below the 3 years for the city and state human rights law filing.
Your Honor, I'm not aware of a First Department case holding that. It is true that there is a case from the Second Department, the Hunt case, which addresses Raymore and Flanagan's arbitration agreement that shortened the statute of limitations for an employee, much like in the case here, although admittedly that was a reduction of 6 months, here it was a reduction to 1 year. But we would argue that that case just simply didn't, in its terse decision, appreciate the context. And really a theme here is that context matters. In the employment context, the potential for an employer to overreach and really prevent, and by the way, these are statutory discrimination claims, right? So while there are cases that involve sophisticated parties, and indeed those are the cases that the Hunt decision in the Second Department cites, they aren't the employment context. They are common law claims. They aren't statutory claims.
But that's a public policy argument that the state legislature has recognized in amending the CPLR, right?
It is, and the problem.
But that provision doesn't apply to the facts of this case because that section doesn't apply retroactively, right?
Right. So while our appeal was pending, and you see that that was one of the issues in this case, which, you know, the court has spoken on in the intervening time during this appeal while we were pending. So what we would say is that CPLR 7515, this court has held, doesn't apply retroactively. That said, it does evince a very strong indication of public policy in New York, right? So while we aren't arguing necessarily to apply directly, we would say it is a pretty strong indication that the legislature does not believe mandatory arbitration should be compelled where it's the employment context, and especially where it's discrimination or harassment claims. That said, here we're not just saying that this is unconscionable or against public policy because it's mandatory arbitration. We're saying in this instance the agreement goes a step further, right? So it's not just mandating arbitration, but it's laying out a trap for an employee, and it's saying not only must you arbitrate, but your time to do so is reduced. We're going to reduce the statute of limitations. Oh, and by the way, if you proceed in court, you're waiving your right to then demand arbitration later. That confluence of things really essentially prevents, as you see, the result in this case.
So you're saying is more. I mean, your brief lays it out well with respect to the troubling gotcha nature of the contractual trap that was laid by defendant. But well, let me know. You're running out of time, so I don't want to take that time from you.
Let me just ask you this: when the employer's attorney sent the letter to the employee saying, "Okay, got your claim, arbitrate it," why didn't your client just do that? Comply with the contract that he signed and do it.
Yes, Your Honor. The problem is there's precedent in New York that's pretty well settled that says once you participate or demand arbitration, you've waived your right to then argue you should be in court. And that's the trap here, right? So the employee who believed very reasonably, and the attorneys very reasonably believed that CPLR 7515 here meant they should be in court. It took a while for that to work itself out. But at the moment that this was brought in court, it was really reasonable to believe it should be in court. So does that mean you're supposed to also simultaneously demand arbitration?
It's an argument. Ms. Miller, what about our decision in Newton that came out this last year?
Yes,
where we dealt with the retroactivity issue. That's one of the cases that I mentioned before. We held that 7515 doesn't apply retroactively, but we really upheld the arbitration clause, reducing the time to file.
That's right. But the arbitration, but in the decision there, the court did say there is a path for the employee, for the plaintiff here, and that's through arbitration. They do have a way to hold the employer accountable. The difference here is at the end of the day, this employee, this plaintiff is left with no avenue.
No. That's only because he didn't avail himself of the arbitration, correct? He could have arbitrated. He had a path. He was offered that path, correct?
If he had taken that,
it's
he
not
would have waited.
right to say he had no remedy. He had a remedy. You didn't like the remedy. You didn't want to arbitrate. So that is not, and that's different from saying there is no remedy.
Well, Your Honor, at the time, it didn't seem under the recently enacted statute that was the appropriate path. And further, if he had here demanded arbitration, he would have waived that right to proceed in court under very.
So there was no clarity. This is before Hennessy, before Newton, right? So our decision had not been issued regarding the retroactivity application of 7515, right?
That's right, Your Honor. And I would just add, I know my time is, but in relation then, if the court is inclined to hold that the arbitration clause is enforceable, we would say at least, right, that tolling should be applied here because there's a very strong analogy to the wrong forum cases, right? At the moment that this plaintiff did not demand arbitration for fear of waiving the right to proceed in court, they were just really essentially mistaken because the law wasn't clear. as to where they were supposed to proceed.
Okay, let me hear from the respondent.
Good afternoon. May it please the court. Ellen Stort from Littler Mendelsohn. I wanted to first start with pointing out for the benefit of my adversary in the court that the First Department has actually upheld a shortened statute of limitations in a case that we cited. It's Ortega versus G4S Secure Solutions. It's cited in our brief, and this court upheld a shortened statute of limitations in an employment application. That statute of limitations was 6 months, whereas the one in our case was 1 year. And that is a 2017 case from this court. In addition, to the extent that counsel is arguing that there was some sort of flap, frankly, I've not understood that argument, even reading through both the moving brief and the reply brief multiple times, and I frankly still don't understand.
Do you really think that the plaintiff in this case had a meaningful choice? I know you try to argue that he did, but the fact is, and I didn't see a response in your brief to the arguments that were being made by the plaintiff here, that basically he got 14 minutes after showing, once he showed up to work, to access the link that was sent to him by the employer that contained the contract, create a password, go ahead and log on. Once he logs on, then he's going to read all of the documents, including the ones containing the arbitration clause. I don't think that that's physically possible.
Thank you for that.
How do you think that that's procedurally conscionable?
Thank you, Judge, for that question. Our motion was a motion to dismiss. So, of course, we have to assume that the allegations regarding the signing were true for purposes of our motion. And I'll even go so far for purposes of this argument to say, okay, assuming that's true, what if there was procedural unconscionability? That's not enough to invalidate an agreement in New York, because you have to have both procedural and substantive unconscionability. And this agreement was written to address, frankly, every possible imaginable scenario with respect to an argument for substantive unconscionability. The court can take notice of the agreement in the record. The employer voluntarily bears all costs of the arbitration, so there's no possible cost issue. The agreement is mutually binding on the employer. And if I may, I'd like to address the equitable tolling issue, if that answers your question, Your Honor.
It does. It does. I mean, at the end of the day, I think that plaintiff's problem, and I'm saying it so she has an opportunity to address it. Her problem is that on the substantive unconscionability, it really rests on the question of whether you can, in fact, reduce the amount of time that a plaintiff has to file a complaint pursuant to the state or city human rights law, which is really 3 years. And we've already ruled on that. So we will have to basically put aside our precedent in order to find that's problematic. Now, notwithstanding the fact that the legislature did recognize the public policy concerns with those clauses, but they're not retroactive to, they don't apply retroactively as we held in Newton. So go ahead and go on to the other issue you wanted to argue.
I wanted to address the equitable tolling argument. First of all, at the time that I sent a copy of the arbitration agreement to my adversary, at my client's instruction, we very intentionally sent it as soon as we found out that the case had been filed. The reason being is that there was still over 2 weeks left on the 1-year statute of limitations. And we wanted to make sure that there was no argument about fairness here, no equitable argument. So I personally, at my client's direction, sent an email to my adversary saying, here you go, you're on notice. There's an arbitration agreement here. We're prepared to stipulate to arbitration. And apparently on the advice of counsel, plaintiff made the decision to not take us up on the offer to stipulate. And his counsel sat by and let the 1-year statute of limitations run and did nothing. To the extent that my adversary is seeking to argue that there was a good faith basis for counsel to think, oh, maybe 7515 would be litigated and come out the way that they wanted it to. At that time, at the time that I sent that email, there had only been one case decided, that was Lateef versus Morgan Stanley. And in that case, the court said the CPLR was preempted by the FAA. And so there was no basis at that point other than a hope and a prayer, frankly. There was no good faith basis for a belief. And I'll just close in saying that to the extent plaintiff still has a remedy here, it's not against the employer.
Thank you. Ms. Miller, you got 1 minute rebuttal.
Thank you, Your Honor. I would just like to correct myself. I thank my adversary for pointing out the Ortegas case. I skipped a step there because the Ortegas case just cites then to Hunt, the second department, this case I was discussing. And as we know, since then, the CPLR 7515 has evidenced a public policy against mandatory arbitration in these types of cases. I'd also just commend the court to take a look at the New Jersey Supreme Court case in Rodriguez. It addressed the same Raymore and Flanagan employee contract as was addressed in the Hunt case to a different result, and has a very good discussion, more that is more time than I would have now, of why.
Yeah. We read your briefs. I mean, I saw you cite to Rodriguez versus Raymore Furniture, 138 8th 528. So I'll read that again and look at this issue. Okay, thank you both.
Thank you.
Thank you.
Lara versus Kadir is the next case.
Yes, Your Honor. Warren Holland on behalf of the appellant, Mr. Kadir. May I begin?
You may. Thank you.
And thank you and good afternoon. This is a relatively simple issue. This is an appeal from a denial of a summary judgment motion, and we respectfully request that the court vacate that denial and enter judgment in favor of the appellant. In this case, the appellant is a homeowner. He hired a contractor who then hired the plaintiff as a handyman. My client was reconstructing a basement staircase when it suddenly collapsed and injured the plaintiff. The plaintiff is now suing on the basis of a negligence claim, claiming that the defendant knew of the defect or should have known about the defect. The problem
your position is that's why you hire Manny, right?
Well, yes, that's one of the.
So you had no notice because Manny actually did the work.
Manny didn't have notice, and neither did the plaintiff. So, of course, the homeowner who wasn't present, it wasn't supervising the work, didn't have notice either. It was a sudden collapse.
Counsel, I'm sorry to interrupt. Are there really no facts tending to show that your client had nothing to do with supervision of the work? What about the plaintiff's statements that he was present and that he was involved in the work?
Well, there's two aspects to that. Plaintiff cited throughout his brief and claimed that my client had supervised the work. Now, there's a difference between general supervisory authority and actual direction and control of the work. My client lived on premises. He was there from time to time. He was able to say things like, I want the staircase here, and that sort of thing. And that's the extent of the evidence in this case. There is no evidence that my client participated in the construction or exercised anything more than mere supervisory control. In fact, and I urge the court to scrutinize all the citations in the respondent's brief, because a lot of times the citations that are provided, if you actually go to the record, they say the opposite of what is being put forth. So that is one of the counter arguments here, is that my client should be held liable because he supervised or allegedly supervised the work. I would note that the respondent argues that there is a Section 200 labor law claim here. There isn't. It's never been pled. But even assuming there were, this has to do with a defect, an alleged defect on the property, which would just take us back to the common law standard of whether the homeowner knew of the defect, created the defect, or had constructive notice of the defect. And again, there simply is no evidence.
These were stairs that were totally constructed by Manny, right?
Yes, Your Honor.
And even plaintiff himself had no notice of the condition. In fact, he admits it, right?
That's correct. On page 85 and 86 of the record, I cited it verbatim in my reply brief. The plaintiff was just as surprised by this collapse as Manny. He actually places blame solely on Manny's shoulders, saying that Manny improperly screwed a 2x4 while they were constructing it. The plaintiff also testified on page 87 of the record that he had walked up and down this staircase numerous times prior to the collapse, had no idea that there was any structural issues, and it was a complete surprise, an unfortunate accident, but a complete surprise.
Okay, let me hear from the respondent.
Thank you. Good afternoon, Your Honors. May it please the court, Ryan Goldstein for the respondent. I believe the lower court properly determined that there was triable issues with respect to not only the cause and create question, but also with respect to whether the property owner, the appellant in this case, was on notice, either actual or constructive. Just working backwards, with respect to the notice, Mr. Kadir did testify that prior to hiring Manny, he did try to repair the stairs himself and did work.
But isn't that a red herring, because that's not what caused the injury, right? The reality is that all of the old stairs have been totally removed, and Manny constructed new stairs that even your client admits he had no notice that there was anything wrong with them.
Respectfully, Your Honor, that's not evidenced by the photos that were provided to the appellant in this case. The appellant received photographs that showed the construction work that was being done, and at the time, the photos were taken at the time when my client was injured. And it clearly demonstrates that not everything was replaced. There was portions of the property that were still in its original form.
I thought that in record at 86, Lara admits that Manny removed the old staircase entirely and began building the new staircase, quote unquote, as soon as they arrived. Is that true or not?
That's his testimony, Your Honor. But my understanding from the photos and from speaking with my client is that portions of the stairs were still in place, and the areas that collapsed were affixed to the portions that were in their original form.
No, counsel, this is Judge Scarpula. That is not what he testified to at his deposition. He didn't put in an affidavit saying that. I mean, he didn't say I misunderstood anything. All that was put in by anybody was his deposition and the owner's deposition. I read through his deposition. He clearly says, I fell on the new part of the stairway. So your statement now that my client said something different, it's nowhere in the record, nowhere.
I appreciate that, Your Honor. With respect to the supervision, there is clear testimony, and there was clear testimony before the lower court that the appellant was supervising this project. He admits that he was present. He admits in page 181 to the question of, were you involved with the renovations? He said sometimes, not all the time. There was also testimony by my client that he was giving instructions to Manny as to how to construct the stairs. Now, my client was not privy to all of those discussions, and I know that the appellant challenges whether that was that's correct or not, but that's still triable issues. Whether
Counsel, as a homeowner, isn't it reasonable that he would be able to say where he wanted his stairs? I mean, wasn't that the kind of direction that was given in terms of where he wanted the stairs and that sort of thing? This was not, as you indicate, his telling him how to construct the staircase.
Respectfully, Judge Renwick, I don't know that anyone, including the lower court, knows specifically what those instructions were, because the appellant, who was the movant, failed to address what those instructions were and what specific involvement the appellant had. So, it leads all of us to speculation as to how much of a role Mr. Kadir had in the construction. He obviously tried to repair them himself, so he obviously felt he was handy and he was aware of how to go about doing this. So to what extent his instructions were in supervising, I don't know. And
I thought that part of the testimony was that he was a little bit handy, but he didn't really know what he was doing. Certainly not do the kind of work that he hired Manny to do. Hence why he decided to spend like $10,000 or more in hiring Manny to get them done, because he didn't know what to do. So I don't know how he could have possibly supervised. This is a private home, right? This is not like a building. So of course he's present in his home, obviously with no access to the basement while the stairs are being constructed. But it's not like he was telling Manny anything other than general things that he may have wanted the stairs to. But Manny was the one responsible, no?
Again, I don't know that any of us specifically know what instructions he was giving. I don't know that there's a clear indication before the record that would indicate that. I will say one more point is that when Manny was hired, Mr. Kadir specifically stated that he was aware that the stairs were in bad shape. And he said that several times throughout his testimony. And there's no indication whatsoever that he took any measures to try to safeguard the welfare and the well-being of my client. And to speak to Manny,
I mean, your time right now, but I would just say that assumes that the fall had taken place with the old stairs. Those old stairs have been totally removed. As I read record at 86, and Manny's and Mr. Lara's own testimony. But let me give 1 minute rebuttal to the appellant.
Thank you, Your Honor.
Now, okay, thank you.
And I'll be brief, Justice Acosta. I think you recognize that there is a difference between the old staircase and the new staircase. What my opponent is discussing when he says that my client tried to repair a staircase, he's referring to an old staircase that was completely removed prior to the accident.
Right.
He also cites page 181 of the record as evidence that my client supervised the work. That's not what the testimony was on that page. My client simply was asked at his EBT whether or not he ever discussed the renovations with Manny, and he said, quote, sometimes, not all the time. Discussing renovations in your own home is different from supervising the work.
Okay, thank you. Thank you both.
Thank you.
Salcedo versus City of New York.
Good afternoon. May it please the court, William Wagstaff on behalf of Appellant Salcedo and Andrea DeMarte. Good afternoon, Your Honors.
Good afternoon, Ms. Wagstaff.
May I proceed?
You may proceed, Mr. Wagstaff.
The issue on appeal, reduced to its essence, is whether or not the motion court properly ignored the contradictory testimony of the parties. At the motion court before it was two parties that averred that they had found a gun and drugs in plaintiff's bedroom, and two parties that averred that there were no guns or drugs, supported by supported by a polygraph test that plaintiff Salcedo successfully passed that dealt with the ultimate issue of whether or not there was guns, contraband, or any of the items that the defendant claimed was the basis for probable cause in the bedroom, and that was something he and his wife would have direct knowledge of. And I believe that this bench has read the brief, so rather than reciting what's in my brief unconventionally, but I think appropriate here, I would ask if there were any specific questions as to potential failures in my brief to address issues or questions. I'd rather utilize the time to address any questions that the bench has.
Counsel, Justice Moulton, there was currency found in the armoire too, allegedly, correct?
Yes, Your Honor.
And did Detective Carroll mention the presence of money in the armoire, or only the presence of a gun and drugs?
Your Honor, no, it wasn't the issue. The issue, unfortunately, that the case is centered around is the basis for probable cause. If there was currency in the bedroom, there's no indication that that would be illegal, and the defendant did not state that that was the basis of probable cause. The basis of probable cause, as stated by the defendant and supported in the documents for the district attorney's office that was the basis for the prosecution, was their allegation that they recovered a gun and drugs in the bedroom. So I don't believe that that really was relevant to the probable cause determination, Your Honor.
Counsel, this is Judge Scarpua. May I ask you, other than, assuming that we take us out the polygraph, other than your clients saying it isn't so, was there any other evidence that would raise an issue of fact with respect to the police officers' affidavits that they recovered the drugs and the gun in your client's apartment?
Well,
other than your client saying, no, we didn't do it.
Respectfully, Your Honor, there was no affidavit of the defendant officers stating that they recovered the gun or drugs in the bedroom. In the moving papers, the only thing that was attached in the motion court was the transcripts. So you have sworn testimony of the defendants.
Oh, I'm sorry, right.
Of the,
I misspoke. The sworn testimony. Other than your client's testimony that disputes that, is there any other facts in the record that would lead to that would raise an issue of fact that that testimony was false, the police officer's testimony?
And I think that's the heart of the issue, Your Honor. There's an imbalance.
I think that's what I'm struggling with.
Is it fair that the court will say we're going to consider the sworn testimony and the sworn testimony alone of the defendant officers, but we're not going to accept the sworn testimony of both of the plaintiffs? Both of the plaintiffs had a 50H and had an EBT, so we're balancing in 4 spots. There was sworn testimony, no guns, no drugs, against 2 spaces where there's guns and drugs. How is that one party is credited, the other party is not credited? At this point, there should be issue spotting. They shouldn't have been making determinations of creditworthiness, whether they're credible. That would be for the trier of fact.
So let me just ask you, so is it your position that any time a plaintiff in one of these cases says, I didn't do that, I didn't have the drugs and guns, that automatically leads to a trial?
No, I think that would be.
So again, what makes this case different? Because there are many cases, as you and I agree, in which the courts have said just merely saying I didn't do it isn't enough. So I'm saying, you're saying, what I hear from you is my client's testifying I didn't do it is enough. And I'm saying to you, is there anything else?
Why don't we let you say it, Mr. Wagstaff?
Yes,
rather than say it for you.
I am not supposing that my client, and to use a pop reference, Shaggy, it wasn't me, is acceptable in any case just to get a trial. However, the totality of the testimony, from his testimony about his initial detention, where they were initially focused on the basement, telling him that he was going to be arrested based on what they recovered in the basement, and telling them, I don't live in the basement. The basement is not my apartment. Then there's the additional testimony with the officer that came outside of the home, trying to get him to sign a confession about what was recovered in the basement. Him saying again, I don't live in the basement. It's the totality of the circumstantial evidence that they, which is our theory, which was pled and which was in the bill of particulars, realizing, oh, we don't have one unit here, we have two separate units and there's no one for us to collar, and transitioning the location of the recovery from the basement apartment to now we found some in the basement, some in the bedroom. So I think this is distinctly different than the automotive cases where the defendant and then a plaintiff in the civil rights case is saying, they didn't have probable cause to stop me, my tail light wasn't out. That makes sense. That's the conclusion. You left your house, the tail light was in, you get stopped, they tell you the tail light is out. You don't know if from the time you left your house to the time that you were stopped, it possibly may have gone out. We all would agree that you should know, and most reasonable people know, what's in the armoire in their bedroom. Anybody that's here, if I was to say right now, there was a gun in the top drawer of your bedroom, I think you would confidently say, Counselor, no, there's no gun, there are no drugs in my bedroom, but it doesn't negate the possibility that right now someone is entering your home, your spouse or another party is putting it there. So I think it's distinctively different here when you take the totality of the record and the location of the supposed recovery.
Okay, thank you, Mr. Wagstaff. Let's hear from the people. I'm sorry, from the defendants.
Good afternoon, Tahir Sadri appearing on behalf of the city. There is the detective who arrested plaintiffs had ample probable cause, thus defeating plaintiffs' false arrest and malicious prosecution claims. They found drugs, and following a search pursuant to a facially valid search warrant, they found drugs and a gun in their bedroom armoire. They also found drug paraphernalia, guns and ammunition in the basement, consistent with the confidential informant's report. And they had the confidential informant's report also that Salcedo had repeatedly used the basement to sell drugs and had apparent control of the basement, having led him to
counsel. What about the issues that your opposing counsel has raised with regard to the other circumstances in the case? And, you know, with regard to I don't know that he mentioned this, but that there are a number of vouchers with no indication of where any of the items recovered have come from, and the totality of these circumstances, and the fact that it's in this case, given the totality, it's the two officers against these two individuals who were taken out of, had no ability to see and question and talk about what was in those spaces, other than to say, I know that wasn't there. Why shouldn't those statements be tested at a hearing?
Well, I think that plaintiff counsel overstates what it is that plaintiffs actually testified to. Plaintiff DeMarte testified she had never seen drugs in the armoire, but she also
says she had never seen any weapons in the house.
She had never seen
any drugs, and she had never seen drugs or a firearm in the armoire before. Right? That's record 141, 142, and the last statement on record 343. And that's only what she says. Mr. Salcedo has additional testimony.
DeMarte testified that she had never seen drugs or weapons in the armoire. Salcedo never testified that he had never seen drugs or weapons in the armoire, or that he had never placed drugs or weapons in the armoire. He did not testify directly to anything. He testified to statements that he made to the officers. He's testified that he stated to the officers who were detaining him that he wasn't a drug dealer, and that
why can you answer me why Detective Fleming didn't see any of that? I mean, in his voucher, he states that he did not know where any of the items came from, right? None of the vouchers contain the source, the location from where the recovered items came from. Isn't that problematic?
Well, I mean, for one, I mean, this wasn't raised below, or that there was, you know, that was as an issue. But I don't think that it is. You do have this, you have the sworn statement of the arresting officer that he recovered drugs and a gun from the armoire, that is both in his deposition testimony and then also in support of the criminal complaint. And again, there was no, and I mean, yes, it was just the vouchers state that they were recovered from pursuant to the search warrant.
Right.
But we don't have any, Stephen.
Although Detective Ramos seems to be very clear that they came from the armoire in the bedroom on the plaintiff's first floor apartment, right?
Yes, Detective Ramos testified very specifically to the specific gun that was recovered from the armoire in his affidavit in support of the criminal complaint. And he also did testify to the drugs being recovered specifically from the armoire. I'm sorry, did I answer your question correctly?
Yeah, it seems to me that the different levels of knowledge on the part, and frankly, some contradictions in Detective Ramos, Carroll, and the detective in charge of drafting the vouchers, right? Or filling the vouchers. Well,
I mean, in terms of the testimony, I don't think that there's inconsistency in the testimony. I think Detective Ramos testified that it was his investigation, and he testified to what he recovered and where. And he also relatively contemporaneously anyway, recorded that information in his affidavit in support of the criminal complaint. And the other officers who were present were not in charge of the investigation and were not reporters, and so testified that yes, they didn't recall exactly what happened five years ago.
But the one recorder doesn't make one single statement in any of the vouchers suggesting that he had knowledge about the source of either the guns or the drugs.
The vouchers do not record where they were
but they usually
specific
do.
area.
I mean, the vouchers that I've examined, you know, sitting in this court for the last, you know, whatever, over 15 years, usually have a lot more information than that, no? That seems like a very important thing to know and list in the voucher, no?
Well, I think that it depends. I mean, it depends. I mean, I think the thing is, with respect to Salcedo, I think that even if you were just going to consider that the guns and paraphernalia and everything that were recovered from the basement, I think that there was probable cause to arrest him on that basis, given the information that they had from the confidential informant that he had, that he appeared to have control over the basement, and that he was answering the door and taking them down to the basement and recovering drugs from from a portion of the basement and selling them there. That, you know, I think that there was probable cause on that ground separately.
Counsel, in order to find as a matter of law that you established probable cause, do we have to credit the officers' respective narratives and discredit or give no weight to the plaintiff's respective accounts?
No, if the plaintiff gives non-conclusory testimony as to what happened, then certainly that should be, you know, that needs to be weighed. But the plaintiffs here only provided conclusory statements that. And
what would I'm sorry for interrupting you, but to my colleague's point, follow up, what would the non-conclusory statements or testimony be in an instance where you can't see what was done? What can you say other than that was not in my house. That was not in my armoire. I am not a drug dealer. What more would you say? You can't say, I saw a police officer, number one, take the drugs from downstairs and go upstairs, because you're not in a position to do so. What would those non-conclusory statements be? Under these circumstances, with looking at, as counsel says, the totality of the unusual circumstances and some of the statements that are made prior to bringing the defendant to the building, why wouldn't these statements be sufficient?
Well, I think that it is possible to make non-conclusory statements as to why you believe that there are not drugs in your house. You can talk about
dealer. They're not drugs there. Obviously, that goes to say, if they're not drugs there, I didn't put them there. How would I be able to say if somebody else did? And I also say I'm not a drug dealer. What else are you looking for?
Well, for one thing, I mean, I think the thing is, even if we were going to say, okay, that we're going to accept these as being non-conclusory, that DeMarte saying that she had not seen drugs or gun in the armoire is not necessarily inconsistent with with the officers finding drugs and a gun, given that Salcedo also had access to the armoire and used it also for his clothes. I mean, certainly it would be it's not inconceivable that he could put drugs and a gun in a drawer that
he's the one who says I didn't put it there. He says there are no drugs or whatever. There are no drugs and there are no drugs there. And she says, I've never seen drugs there.
Salcedo's testimony was limited. He said that he was not a drug dealer and that he did not own a gun and that nothing they found there was his. Certainly saying just nothing they found without being specific is a pretty generalized statement.
But he was referring, if you look at record at 272, he's referring to the search of the basement. He said, that's not my apartment. I don't live there. Right?
Well, okay.
That's not my apartment, he says at 274. Somebody else owns that apartment, officer.
I mean, aren't you putting a little too fine a point on exactly the wording that one has to say in order to come up with a basis to have this hearing? I mean, should we not be looking in the same way at the fact that the items that were taken are vouchered without even a distinction as to where they were found?
Well,
I mean, should we put that kind of fine point on that as well?
I don't think that
question the credibility of the officers here as to whether or not there's a basis for the hearing. I mean, you have officers who are going into an apartment who are saying they have found drugs in particular places, and then you have vouchers that don't even specify where these very important items were found. But you want to put such a fine point on the fact that it's conclusory because a person said, I didn't, the drugs aren't mine, I'm not a drug dealer, or I didn't see drugs, or however it was said.
I don't think that I'm putting that fine a point on it when he's saying I'm not a drug dealer. Salcedo never testified that he did not have drugs in his home. And I think that it is also important that he did not provide any direct testimony. The testimony that he provided was, this is what he said to the officers. And that's hearsay. When you're considering it for its truth, that is hearsay. That's not,
but it can be used to defeat summary judgment. Haven't we found that plenty of times in this department? Even hearsay testimony is allowed to defeat summary judgment.
I don't believe that is correct unless that there is some reason why you can't provide non-hearsay.
You relied on that. You relied on that testimony as well. If you rely on it, then they're certainly.
I don't understand how we're relying on it.
I believe you submitted it, didn't you?
We submitted all of the deposition testimony, but in terms of providing basis for probable cause. I mean, we relied on the testimony of the officers and the arrest evidence and the criminal court evidence. I mean, in terms of providing
there were
cause.
also sworn statements by the plaintiffs themselves, right? There was a 50H hearing in which he testified under oath, right?
Right, but what I'm saying is he did not testify either at the 50H hearing or at the deposition. He did not testify directly that he did not have the guns or the gun or the drugs in the armoire or in his home. He did not make it. He testified to what he told the officers who were detaining him. He did not make that kind of statement directly, and he did not submit a sworn affidavit to that effect, which he plainly could have done. Just one other point that I would like to make in terms of.
I'll give you 20 seconds. I think we spent a lot of time on this case.
I apologize, Your Honor, but in terms of the sequence of events, it is undisputed. It's in accordance with DeMarte's testimony as well, that the officers first searched the basement and then searched the first floor apartment. And so the fact that there may have been some statements regarding what happened in the basement before what was discovered on the first floor is not inconsistent or problematic.
Okay, thank you, Mr. Wagstaff. You got 1 minute rebuttal.
If we could briefly recenter the conversation to what is before the court is whether or not, as a matter of law, it was appropriate for the motion court to find no material issues of fact. The bench has shown through its colloquy and discussion with the attorneys that there are plenty of issues that are unresolved. Unresolved either because of the fallacy of the documents that they were presented to try to support that items were found in places they weren't, as well as the testimony.
Mr. Wagstaff, let's talk about the items that were found in the basement and the confidential informants information that he had been with Mr. Salcedo in the basement. Does that give probable cause for Mr. Salcedo's arrest?
No, Your Honor, and as an initial matter, that wasn't the basis that any of the parties claimed was the probable cause. The arresting detective did not say we had probable cause to arrest the parties because they had constructive possession of what we found in the basement. That wasn't the position. That wasn't in the moving papers in the motion court, and it was now in opposition to my brief before this court, for the first time, an expansion of the theory of probable cause by virtue of there being constructive possession of what was in the basement. In addition, even if you want to entertain that probable cause argument, there's still a material issue of fact because there was testimony that was contradictory on each side. My clients state that they had no control over the basement. It was locked. They didn't have the keys. The defendant said that they didn't need to kick the door down, that they believed that it was open. So even if you were going to extend your inquiry into whether there was probable cause based on what was in the basement, you still have a material issue of fact over the dominion and control over the basement when my client had a lease only for the first floor.
Sir, did Mr. Salcedo and Ms. DeMarte have equal or shared access to the armoire?
Yes, it was theirs. It was the armoire in the bedroom, husband and wife, and they both would put their clothes in there.
And counsel, may I ask you, is counsel for the defendant correct that your client never directly denied that there were drugs and guns in the armoire?
I think that's a mischaracterization. In the record at 276, it said, "I do not own a gun. I'm not a drug dealer." If there's anybody that could be blamed for there not being the direct answer, it's the questioner. He wasn't asking himself at the deposition the questions. If the attorney then representing the city asked the question, and then that's the response to the question that they ask, if there's not the fine point, as Justice Renwick stated to the issue, then that's on counsel for not asking follow-up questions.
No, but I'm just saying to you, I have to go back and read it. But if the question was, was there gun and drugs in the armoire? And the answer was, I don't own a gun and I'm not a drug dealer, that is not responsive to that question, right? I mean, I have to go back and look at it. I'm just curious as to whether or not you agree that with counsel that he never denied that there were drugs and guns in the armoire.
I wouldn't agree, Your Honor, and I would state that as the opponent to the summary judgment motion, all favorable inferences belong to the opposing party. In addition, it was stated in my brief, and probably you guys said, why does he keep saying this, that both of my clients are Spanish-speaking individuals first, and English is their second language. Ms. DeMarte had to do her 50H and her deposition with a translator. So the translation and the understanding, the level of precision that we may expect from an English-speaking person is not likely to be in this circumstance.
And that's a good point.
Thank you. Thank you, Mr. Wagstaff. Thank you, counsel. Thank you both. We will definitely scrutinize this case and all the others. People versus Wilson.
Can you hear me now? Yeah.
Yes, we can.
Okay. So this is a case involving the defendant taking a plea to the charge of 265-13-2 and getting a 19-year sentence by the court, in a determinate sentence. He was facing 5 to 25 years on the sentence for the conviction under that count of the indictment. However, the judge did not give him any kind of leniency and imposed a 19-year sentence on him at the high end of the range, which is 5 to 25 years.
Well, that's after they found him after 2 years, right? Didn't he? Was he a fugitive for 2 years, Mr. Weinstein?
Your Honor, the defendant claims that should be struck from the record, being a fugitive. That he took a plea, he admitted he was guilty, and what he's claiming is that he should have been given a more fair sentence. This is his first felony conviction, and he faced 5 to 25 years, and the judge gave him the high end of the sentencing range.
Why did the judge explain why, Mr. Weinstein? The defendant was part of a very large operation here.
I understand, Your Honor. However, the judge did not consider certain things. First of all, the judge said on his commitment that the probation report, pre-sentence investigation report prepared by probation was in the record and was attached to the commitment. It wasn't attached. The letters that I referred to, which this court made part of the record by enlarging the record pursuant to my motion, were not considered by the judge, were not mentioned even during the sentencing hearing. And the main thrust of my argument is not that the district attorney claims that these letters should show that the defendant should be given leniency, but that the court never considered them. That this court should now.
Well, were those letters before the court? Because that's part of the problem here, right? That you're relating off the record discussions with counsel. And I'm not clear to what extent the court is aware of the letter exchange. Were those letters before the sentencing judge?
Well, that's the question I have, Your Honor, and no one could clear that up. And the judge that is involved here is a retired judge. But at the time of the sentencing, he didn't even mention the PSI investigation report. Was
there a pre-sentence report here? I'm sorry, was there a pre-sentence report here?
Oh, yes, there was, and he said it was attached. One of the problems in this case is that the record that the court considered wasn't complete. For whatever reason, this court decided not to make mention of the pre-sentence report in the sentencing hearing. In addition, and I spoke to somebody from probation recently, and I asked them, is that a common practice? And she said no. And the judge signed the commitment and said he signed and checked off the fact that there was a pre-sentence investigation report, but it was nowhere in the record. In fact, I went to the appeals clerk's office to retrieve the letters that I wound up obtaining an order from this court enlarging the record, because they were letters that should have been considered by the court at some point as to whether or not this person should be given a more consideration as to leniency than.
What are you?
How old was this defendant?
This defendant, I think he was older than a youthful offender at the time.
Well,
So he was not a youthful offender.
well,
I could check
How old is
the
he
age.
now?
I could tell you if I
Yeah.
get. the
No, it's
percentage.
fine. What are you asking for, Mr. Weinstein?
I'm asking that this court give this defendant for the first time a full hearing on all the record that's presented in this court.
well,
You
we
know-
have the power to reduce. Are you asking us, and this is a, you're asking for a reduction?
Well, I'm
of
asking for
sentence here.
both, Your Honor. I'm asking for both, but if this court doesn't feel that it can weigh the record and that's available, that was not considered by the previous judge, then certainly I would, ask that this court sit and bank an original jurisdiction on the issue. But I didn't think this court, the appellate division, actually likes to sit and decide.
No, we don't, but we have interest of justice jurisdiction in which we can reduce the sentence, Mr. Weinstein.
Well,
So I know the maximum was 25 years. He got 19. So my
Right.
question is, because I didn't find that in your brief, what exactly are you asking for?
he asked for
10?
10 years, and the 10 years that I'm referring to doesn't come out of the blue. I had to really grill the defendant to find out where he came up with the 10 years. And you can see, in addition to the letters from these people who recommended him some leniency to the judge, the lawyer, Paul Brenner, sent a letter urging that 10 years. So there must have been some discussion between the defendant and Mr. Brenner as to 10 years. The defendant brought that up to me in the very beginning. So what I'm asking this court is to either grant a reduction in sentence more like the 10 years that he thought he was going to get, because he's never taken back his plea, or else remand it to the lower court for a hearing.
Thank you, Mr. Weinstein. Let me hear from the people.
Good afternoon, David Gagne for the people. May I proceed?
You may proceed, Mr. Kanye.
Your Honor, it was apparent to me in reading Mr. Weinstein's brief that he was asking for a reduced sentence based on these letters that were, purportedly not shown to the trial judge, although they were addressed to the trial judge. They were addressed from his defense counsel and they were sent to the trial judge. I can't be certain whether or not those letters were seen, but they were addressed to the trial judge and they were sent prior to sentencing. Now, the fact that, or the question of whether or not the trial counsel promised the defendant that he would receive a 10-year sentence if he pled guilty, that may be a basis, if that were true. If that were true, that may be a basis for vacating his plea because it was not knowing, voluntary, and intelligent. But it would not be a basis for reducing his sentence, which is the only relief that my adversary is seeking on appeal. But furthermore, there's nothing in the record to suggest that his claim had any truth to it. There was, beside the letters show that his counsel urged the court to impose a 10-year sentence. It did not suggest in any way that counsel had promised the court, defendant he would receive such a sentence if he were to plead guilty.
Was there a discussion with your office about 10 years? That's still what I'm not clear about. I mean, the letter seems to suggest that there was a back and forth between your office and defense counsel. Is that not the case?
Respectfully, Your Honor, I don't believe that the letter suggests that at all. I believe the trial counsel was simply urging the court to impose a 10-year sentence. I don't think there was any mention of a discussion with the district attorney's office.
But the question is, was there any offer made I think a part of that question is, was there any offer made, or was there ever a discussion for something involving 10 years at an earlier time?
Your Honor, there's nothing in the record to suggest that there was any offer that was made for 10 years. Or that
Counsel,
there was any discussion at all.
counsel, one of his co-defendants with a similar charge got 20 years, correct?
That's correct, Your
And
Honor.
there's a bunch of people who got anywhere between 10 and 20 years, correct?
That's correct.
So as with respect to other people with whom he was charged, this wasn't significantly higher than at least one other person who was charged with a similar crimes, correct?
That's correct, Your Honor. The individual you're referring to, Dario Weinerman, he received a 20-year sentence, and only this defendant and Mr. Weinerman were convicted of criminal sale of a firearm in the first degree. All of the other co-defendants either pled or were convicted of lesser charges. And in fact, the trial judge said...
Can you remind me, sorry, whether Mr. Weinerman, did he have a record? Had he been arrested before? I can't recall from the...
Your Honor, I don't have that information in front of me.
In other words, I'm trying to find out whether his range was the same, whether he had a previous, conviction or anything. I think that for this individual, was this his first conviction?
This was his first felony conviction, yes, Your Honor. But I would just note on that point that this was not an isolated incident. It's not as if this was just one occasion.
No, there were 41 firearms sold, and there were, I think, 38 occasions where they came together. There were 17 other people involved in this conspiracy. I'm not sure if that's the right number, but there was something like that.
That's correct, Your Honor.
And several other counts. He pled to one of which I think one count that involved 8 firearms. Is that right?
That's correct, Your
Honor. Mr. Kanye, the letter, counsel claimed that the letter that Paul Brenner gave to the court was also copied to Christopher Prevost, who's an assistant district attorney at One Hogan Place. So did you check whether those letters exist, whether you had them?
The letter itself? Well, we know the letter exists. But I don't think that there's any indication that the letter was sent to him that there was any discussion about from our office offering a 10-year sentence. That there was any discussion whatsoever of 10 years.
Sir, is there any ambiguity in the record as to whether the sentencing judge had before him the pre-sentence report?
It's not clear in the record whether or not the trial, he doesn't make any explicit reference to the pre-sentencing report.
Okay, thank you, counsel.
Thank you.
Let me give 1 minute to Mr. Weinstein.
Yeah, so I did get asked some questions. So one thing, the defendant was born in 1992, and these incidents occurred in 2011. So he would have been between 18 and 19, I believe, my calculation. The other is that I don't know, and the district attorney said he doesn't know whether or not these other individuals who one of the judges, I think, Your Honor, Honorable Judge Scapula, said that the other ones got similar sentences to him.
I think it's Scarpula, but that's
I'm sorry. I apologize.
It's Scarpula. Scapula is a bone in your body, but okay.
Okay, I apologize, Your Honor.
That's okay.
So that I wasn't able, first of all, I had not gotten all that information until the brief was filed, and then to be able to check the records. I've had a lot of problems trying to get records from the clerk's office with regard to files of cases that I have, much less ones that might have been sealed or whatever could have happened. So I can't argue that, each and every one of those points that he made about other defendants. The other thing is that the letter certainly was sent to the district attorney. That's one of the reasons this court granted the enlargement of the record, because it's stamped by the district attorney at a time and date, May 13th, which is likely to be around what it would have gotten to him, since the letter was dated May 12th from Mr. Brenner. So there seems to be no issue, and I don't think Mr. Gagne is even claiming that. But not only that, this defendant is a first-time offender. Even if the others were first-time offenders, I think this judge was a little bit too harsh in posing sentence. But my experience with that,
really? No.
With my experience with this judge, because this judge handled a lot of gun sale cases. He would do the applications for wiretapping. And then he wound up having those cases. So,
okay.
Thank
you, Mr. Weinstein.
Okay.
Thank you so much.
Thank you for your
everybody.
time. Thank you for your time, Your Honor.
You got it. Okay, 150 East 3rd Street is going to be called last. So the next case on the calendar is Sharma versus Walia.
Okay. Okay, can you hear me?
Honor?
Yes.
I can hear you and see you, so.
Okay, thank you, Your Honors. I represent the plaintiff appellant in this matter, if I can be heard. Basically, it's involved, as I'm sure you've seen, the sale of 3 Subway franchises. Now, the major issue here is the most major issue, I think, was that the judge ruled that my client did not show reasonable reliance on the misrepresentations of the defendant. Now, the issue here, bottom line, is that there was 3 written contracts for 3 separate Subway franchises. My client purchased
we're familiar with the facts, Mr. Bronner.
Okay.
The question is, why did your client not read all of those documents?
That's it. That's the major point. That's the major point on the contention. My client's statement, and on a motion to dismiss, as I said many times in my papers, her statements have to be accepted as factual. You can't, at least they're worthy of a hearing. You can't just say, we don't believe it. You've got to accept it as
well, let's assume we believe it. That doesn't mean that she was justified in not reading the documents in a transaction involved hundreds of thousands of dollars.
Well, that's the point. She's saying she never had the documents. It's the major point of the documents being the actual subleases. She paid an additional, as a fact show, $575,000 for execution of option renewals, as represented by the defendant. But those option renewals never existed. And she's also saying that that he, as part of this fraudulent scheme, never gave her the documents. He always withheld the subleases. She only saw them after the closings, the 3 closings. She never got it before.
But counsel, did she have, I'm sorry, this is Justice Moulton. Counsel, didn't she have the ability to ask for the leases before going to the closing? Or even at the closing, say, give me a minute, let me read the leases?
Again, we have to look at the whole picture. This is somebody who was defrauded, snookered, really, any way you want to put, hoodwinked, to pay an extra $575,000 for option renewals that didn't exist. What that shows you is a degree of, this is a novice buyer with a prior relationship with the seller, and she relied on him. She didn't have an attorney. She did not have an attorney. And as part of the scheme, she believed that whatever he said, that was who she done it.
You have to argue how that's reasonable. It has to be reasonable. Counsel, please don't interrupt. It has to be reasonable reliance, and you haven't given much on the reasonable part of that. I mean, you said she didn't rely, or she relied too much on Mr. Walia, but was that reasonable?
It's reasonable when he, and I have case law which I presented, when he takes steps to hide. The main document was the subleases themselves. He actually withheld it from her.
But this is in the context of a fraud claim, counsel. You're not alleging that Walia misrepresented parts of the lease. What you're saying is that basically Walia told her she didn't need to read the lease, and she had just signed them, even at closing. She didn't even ask, well, I can't close because I have not read the documents. she says, well, I took his word because he's a friend of 25 years, etc. I mean, is that reasonable?
No, our claim is that he actively misrepresented to her that the whole basis she paid an additional $575,000 was because he actively represented that he had discovered that there were option renewals contained in the sublease, but he never gave her the sublease. He always withheld the sublease. So there was an active misrepresentation as to the terms of the option of the sublease, that they contained option renewals. The $400,000 she paid pursuant to the written contracts was for the subleases. Then he comes and says, I've discovered that there are option renewals, 5-year option renewals, therefore it's worth more. Therefore now pay me a total of, it turned out, another $575,000 for a total of $975,000.
So you think that, I mean, because I hear the Court of Appeals saying that you need to use or exercise ordinary care and intelligence before you can claim that you justifiably rely. So you dish out your client, $975,000 based on the word of somebody. Yeah, she's known him for 25 years, but he's not even a relative. He's not a brother. Usually I've seen cases, the line of cases that talks about, siblings or people in a confidential relationship. But I don't even hear you asserting that. I hear you saying, well, he's a friend of 25 years. Therefore, it's okay for me not to read a bunch of documents in which I have attempted possession of 3 different franchises in different locations, and not, without reading a single document.
Well, what my papers say is that he was a experienced seller of franchises. This was her first time. She relied. She didn't have an attorney. He knew that she had no knowledge. He created like a fraudulent scheme, because just the fact, and I've given case law to that effect, of her paying $575,000 for non-existent option renewals indicates that something is just wrong, that there's something absolutely terribly wrong here. And to her, she just.
Mr. Briner, you're not going to hear anything from me contradicting that. Clearly, she was taken. Clearly, there were issues here, words on which she relied on. The question is whether it's reasonably justifiable or not. But we've really exhausted your time. So let me hear from the respondent.
Hi, Your Honors. I appreciate it. My name is John Carroll. I represent the respondents. May I please the court?
Thank you, Mr. Carroll.
I think Your Honors have actually hit upon one of the 3 bases that these 3 sets of fraud allegations have been dismissed. And there are 2 others I want to point out: statute of limitations basis, which is equally fatal, as well as the fact that the allegations as presented to the court were promissory in nature. We have some additional problems with this particular appeal because the appellate papers by plaintiff appellant are citing to the wrong document. The operative complaint is the second verified amended complaint. And so when you look at the factual allegations being posed here, oftentimes respondent.
But we don't need to, based on Lynch, there's no basis for us to dismiss the appeal because plaintiff relies on a proposed 3rd amended complaint rather than the 2nd amended complaint. We don't need to dismiss on that basis, right?
I think you might, because it's not properly before.
We might, but Lynch doesn't require it, right?
I believe you have the ability to look into the entire record, so you can. But I do note that, 1, there was no motion to amend made. There is no motion to relation back made. So you have here a document that is not verified nor sworn. It's not attached to Sharma's affidavit, so it's not sworn by her. All it is a wish list, and it's significantly different than what was alleged in the operative pleading, which is the 2nd verified amended complaint. So again, this is probably the 5th or 6th shot that plaintiff has had at amending these allegations. So, and they're contradictory. And we laid that out in our brief fairly well, so I won't belabor the point, but it is significant.
There's no breach of contract claim here, Mr. Carroll, is there?
Initially, there were multiple causes of action alleged. They were withdrawn on the basis, what happened is that we made our first motion to dismiss, and then I think it's the law of the case that what transpired is that they were granted another opportunity to amend, and this is what led to the 3 surviving causes of action, sounding and fraud, being the remaining claims.
Okay. Okay, thank you.
Thank you.
Let me give the respondent a minute.
Two things. First of all,
Ellen, I'm sorry.
The judge herself indicated in her decision that the third complaint is the complaint, not the second complaint. And so that's based on the third complaint. So I don't see counsel's point.
No, we can address the merits, I think, based on Lynch versus Consolidated Edison. That's our decision back to 2011. So I'm fine with that. The question is still the justifiable reliance point.
Right. The other point is that case law indicated that if there's a crucial document which is being withheld by the defrauding party, let's say, then he cannot come and say there's no justifiable reliance, because he had to possess the document.
But did she ask for it? Did your client say, listen, I know I trust you, we go back 25 years, but this is a major transaction here, and I want to read the documents before I put my signature on the dotted line. Can you please give me the documents? There's nothing in the record suggesting that. She just simply took his word for it.
Yes, but I think you have to look at, I have case law indicating that when there's such obvious fraud, everything is tainted by that fraud. He went out, it's even presumed that the defrauder went out to create a fraud, to deceive. And so I think we can look at that and say that he like pulled all the strings there, and she just fell into it.
Yeah.
If he hadn't withheld it, if it was in her possession, the judge's decision seemed to be she could have read it because it was in her possession.
Okay.
She's saying she never had it in her possession. That's the basis of the judge's
decision. Thank you, Mr. Bronner. Thank you, Mr. Bronner. Thank you, Mr. Carroll.
Thank you.
People versus Bing.
Good afternoon, Your Honors, and may it please the court. I'm Stephanie Sonsino with the Office of the Appellate Defender on behalf of Mr. Kaleem Bing. May I proceed?
You may, Ms. Sonsino.
Thank you. I'm here today to ask that the court reduce Mr. Bing's sentences for first-degree assault and first-degree bail jumping in the interest of justice by running his 2 sentences concurrently. Given the tight nexus of facts between the assault and bail jumping convictions and Mr. Bing's background, the specific facts of this case strongly indicate that Mr. Bing's capacity for success with concurrent sentences.
Ms. Sonsino, your client got 1 year above the minimum, correct?
On the assault charge, that's correct. Yes,
right.
Your Honor.
So, I mean, given stabbing your wife in the face is not something that endears you to the sentencing court, right? So explain to me why we should put all of that aside and reduce the sentence.
Certainly, Your Honor. And Mr. Bing at no point tried to minimize his responsibility in this case. The fact of the matter, however, is that Mr. Bing was married to somebody who was twice his age. They had an abusive relationship. And between the time of the underlying assault and the bail jumping, Mr. Bing received several threats from the complainant. The complainant stalked his young son and grandmother, and Mr. Bing was also dealing with mental health issues at the time.
Did he get an order of protection?
Yes, Your Honor, precisely. He did receive an order of protection.
Because we weren't sure from the record whether he had or not.
Yes, so I would also argue that given the court's promise to grant Mr. Bing an order of protection, protecting him, his young son, and grandmother from Sotomayor, the court clearly credited Mr. Bing's fears of Sotomayor and his spouse in the case. And I therefore believe that concurrent sentences on the bail jumping and assault charges are appropriate in this case because the bail
Let
jump.
me just ask you, the court also gave Sotomayor an order of protection, correct?
That is my understanding. Yes, Your Honor.
Yeah, so I mean, the both of them are supposed to stay away from each other. It's not saying one party, it's saying both parties have issues here, right?
Certainly, and there's no doubt about that in this case. Both parties certainly had issues.
Counsel, oh, go ahead, Judge.
No, you go.
Counsel, what were the facts underlying the bail jumping charge and ultimately the bail jumping conviction?
Certainly. So the facts underlying the bail jumping charge and conviction are as follows. After the offense, Mr. Bing turned himself in voluntarily to the court. He was released on bail, and pending the proceedings in the underlying assault case, he received multiple threats from his spouse, Sotomayor. He had a real fear of Sotomayor, who not only threatened him via text message, but slept outside his young son's house and followed his son and grandmother. And so Mr. Bing fled to Pennsylvania out of fear of Sotomayor, not a desire to evade responsibility in this case.
And did Mr. Bing take the child with him when he went to Pennsylvania, or did the child remain in New York?
Those facts are not in the record, Your Honor. My understanding is that the child remained in New York, but I couldn't say for certain based on the record.
And counsel, let me ask you, that recitation that you just gave, that's his statements, right? Was there any fact finding with respect to that, or any decision or order or anything from anybody that tested his view of why he left?
Well, Your Honor, the record is not entirely clear vis-a-vis those things.
I mean, he says that's what happened. I'm just trying to say,
certainly,
I'm just trying to figure out, is there any independent corroboration of that?
Well, I would urge this court to consider the trial court's decision to impose mutually protective orders of protection as crediting those statements.
Another reason for hope to complain or them to.
Yeah, there's someone that needs to mute.
Thank you, Your Honor.
Go ahead, Ms. Orsino.
So it seems to me that the trial court judge, who was in the best position to evaluate the credibility of Mr. Bing's statements, credited his statements because the trial court.
Just let me ask you, is it common for a court to give out orders of protection to both parties in instances like this?
This is a very unusual case, Your Honor, so it's difficult for me to say that reliably. I don't have the empirical data I would need to come up with a verifiable answer to that.
You're right. But let me put it a different way. Well, I don't know that it's one that you can answer, but I think courts are rather cautious and searching before issuing an order of protection for a party. I mean, there's inquiry, questioning, such.
Certainly, I would agree with Your Honor about that. It does seem like the trial court below would not have issued a mutual order of protection had it not had concerns, both for Mr. Bing, who was incarcerated at the time, and his young son and grandmother. I therefore think that there's strong evidence that Sotomayor, Mr. Bing's spouse, really did pose a serious threat to Mr. Bing and his family.
The sentence was imposed in how much time has he served?
He has served, I think, about
3.5 years
of his sentence at this point.
How many?
I think 3 or 4 years of his sentence at this point.
Okay.
So the reduction would be quite meaningful to him still. It would return him home to his young son and grandmother 1 to 3 years sooner. Or if the court were willing to reduce the assault to the minimum as well, to the 5 years, that would get him home 2 years sooner.
Okay. Okay, thank you, Ms. Orsino. Let me hear from the people.
May it please the court, Brent Yarnell, people, may I proceed?
You may.
Thank you, Your Honor. I'd first like to clarify the record on the order of protection. The court issued a written order of protection against Mr. Bing in favor of Sotomayor. In response to Defendant Bing's oral comments at sentencing, the court orally directed the prosecutor to orally direct Sotomayor not to contact Mr. Bing, but there was no written record of protection issued against Sotomayor in favor of
Was
Mr.
there
Bing.
any question? Was there any evidence challenging his assertions that he was being stalked, that Ms. Sotomayor was equally the aggressor? Or putting him
I don't know of any evidence undermining those claims. What I would say is that the judge explicitly stated on the record that he took those claims into account in deciding to give Defendant Bing a very lenient sentence, only 1 year above the statutory minimum. And the judge explicitly stated that although he did think that the various mitigating circumstances that defendant cited did warrant a more lenient sentence, he did not feel that the absolute minimum sentence was appropriate in light of the brutal nature of the crime shown in part by the photographs that the sentencing judge reviewed. I'd also like to clarify the record with regard to the circumstances of Mr. Bing's turning himself in and the bail jump. He did turn himself in. He turned himself in 3 months after the assault. So he fled the crime scene and then turned himself in 3 months later. On his bail jump, he didn't just miss a court date. He fled the jurisdiction from New York to Pennsylvania for a 6-month period and had to be brought back in on a warrant. He did make claims that the reason that he did it was because of this abuse, but notably, he never notified the court of the abuse. His attorney never said anything about this issue. He just fled from New York to Pennsylvania for a 6-month period. The final thing I'd like to note with regard to the 5-year term of post-release supervision, this was not Mr. Bing's first violent crime. In 2009, he received a youthful offender adjudication for first-degree robbery with the use or threatened use of a dangerous instrument. I certainly think that's violent. He also, at the same time, received a youthful offender adjudication for selling illegal narcotics. And while he was out on bail for the present assault charge, he was arrested again for selling marijuana and jumped bail separately in that case. So there were 2 bail jumpings on the record before the trial judge. Based on this criminal history, the lenient sentence, and the brutal nature of the stabbing, we think that this sentence was more than appropriate and it was totally lenient. We ask that the court affirm the judgment. Thank you.
Thank you, Mr. Yarnell. Ms. Oncino, I'll give you 1 minute.
Yes, Your Honor. First, I'd like to address Mr. Bing's so-called criminal background. He was charged with youthful offender conviction. He has youthful offender convictions. He was tried as a youth. We treat youth differently than we treat adults for good reason. It's because they have less culpability. And the marijuana charges that the prosecutor cites were dismissed. And the bail jumping charges most likely were related to the same fear and that led Mr. Bing to flee to Pennsylvania. Furthermore, I would like to say that while the court did acknowledge that it was giving Mr. Bing a shorter sentence on the assault charge due to the surrounding circumstances and his relationship with the complainant, it never addressed its decision to run the sentences consecutively rather than concurrently. So even if this court did agree with the lower court's decision to give Mr. Bing a 6-year sentence on the assault charge, there's no reason that this court shouldn't reduce his sentences by running them concurrently, given the facts of this case and Mr. Bing's background.
So concurrently, that would be a total of what? Rather than reducing the assault to the minimum of 5.
Certainly, that would be 6 years with 5 years of post-release supervision.
Okay. All right. Thanks.
Thank you so much.
Thank you both. Okay, Lewis versus 311 Realty.
May it please the court, my name is Nicholas Herzler and I represent the appellants. May I proceed, Your Honor?
You may.
Your Honors, defendant submits that in this case we're entitled to storm in progress defense for an outdoor accident. Because when you look at the photograph at page 200 of the record,
Is
and you look at
is that undisputed? Because I didn't hear the respondent arguing that somehow it was not snowing. Was it snowing during the accident?
it's undisputed that it was snowing at the time of the accident. If you look at 135 of the record, if you look at 750 of the record, this is the plaintiff's papers in the lower court. A snowstorm was ongoing at the time of the accident, and quote, admittedly, this is not a case about defendant's failure to clean the snow off the exterior landing. We know from the weather expert, we know from the video that it was snowing, and we know from plaintiff's testimony that she slipped because of snow that was ongoing. This isn't a case where there was like prior snow or something like that. They're not claiming that.
Right. They're saying it was, when she fell in the exterior landing, which was partially covered by snow, but she also admits that it was snowing, correct?
She admits that it was snowing in her testimony, but what the lower court made a mistake in saying this was an indoor accident.
Right.
We
got that. We got that.
And the plaintiff's brief, throughout the plaintiff's brief, they keep trying to say it's in a vestibule, which would be indoors, and they apply case law, which talks about indoor accidents. Now, you can have storm for an indoor accident if it's tracked indoors, but it's a higher standard. And what we're saying here is that outdoor accident, and it doesn't matter that there's a partial roof because this is exposed to the element.
Okay. All right.
And so we meet our prima facie burden by showing that it was outside and it was a result of storm in progress. We shift the burden of proof to the plaintiff. The plaintiff relies on a recurring condition theory, which shouldn't be considered because it's not pled. They say that they don't have to plead it, but in our reply brief, we cite case law that show you have to plead it. But even if considered, even although it's not pled, they don't cite evidence in support of recurring condition theory. They only say, well, the testimony showing that one of the witnesses said, you know, it might become slippery. It's possible. But there's numerous cases like Salazzo and Kowalski and others.
Wait, it's recurring in the sense that every time it snows, it's slippery, right? Although that's not a basis on which we have found liability.
Yes, Your Honor. In other words, a general awareness that it might become slippery is not enough to raise an issue of fact under the law.
I was trying to bring some humor into it, you know. It's a long day. So thank you, counsel. Your time ran out. Let me hear from Mr. Della Carpini.
Good afternoon, Your Honor.
Thank you, Judge.
Please the court. Christopher Della Carpini for the respondent, Ms. Lewis. Your Honors, I think the best argument for why storm in progress does not apply here is nothing I wrote in my brief. It's a photograph at page 367 in the record. This is where the accident happened. It didn't happen on a sidewalk. It didn't happen on a staircase at a train station. It didn't happen on a pedestrian access ramp or any other exterior location like that. It happened on this landing, admittedly outside the front doors of the building, but in the landing that is completely covered with it.
But isn't that an exterior landing? I mean, if you see the door, just showing your photograph, snow gets in there. Snow that is blown in, you know, that's exposed to the elements, isn't it?
Yes, it is. And so is the lobby when you open the door. That's why this doctrine does not apply when it gets in there. That's why Justice Taylor was right here. This is not like an exposed area that you can't expect a defendant to take care of. This is not a parking lot. And not only that, the defendants had a plan for taking care of this spot. It was completely within their control. And Mr. Medina's testimony is very good on that. It's not general awareness. He knew specifically when this floor gets wet, it gets slippery. And we have a plan to take care of that specific condition. It's called putting down rugs. We put down salt. This is his testimony. It's in our brief at pages 10 and 11 and 26 to 27. One of the reasons you throw down salt on that black floor be because it becomes slippery. Answer, yes, exactly, because the whole area can become slippery. That's why one throws salt. So whatever reason there is for applying storm in progress to any other spot in this state, there's no reason to absolve the defendant of their liability for reasonable care over the landing, which is enclosed on 2 sides, 3 if you count the roof.
So when were they supposed to engage on that remedial, throwing the rug, etc., after or before or during a storm in progress?
Oh, before. Mr. Medina, I think, is the one who testified they were watching the weather reports. They knew when this was coming.
Yeah.
They had a plan. The issue for the jury here is whether they followed through on their own plan.
Okay.
The other points raised in the appeal, defendants say we can't argue lack of notice because we supposedly did not plead a recurring condition. What we pleaded in the bill of particulars, page 61 and 62 of the record, was, among other things, failing to prevent the floor of the subject premises from accumulating snow, ice, and precipitation. If 311 didn't see a recurring condition pled there, then they don't know what snow is. Speaking of which, Mr. Medina gives us constructive notice. Defendants may have proved a prima facie lack of actual notice. They have no prior accidents, no prior complaints. That's all well and good. But Mr. Medina tells us in his testimony, pages 26 and 27, he knows that this spot gets wet. When we get snow, he knew snow was coming. He knew there was a plan. You put down rugs and you put down salt, and he explains why. Mr. Grinstrom may say that this was some special kind of surface of floor that never gets slippery. Mr. Medina raised an issue of fact on that. So we have evidence of constructive notice. The last point in this, Justice Taylor also correctly found issues of fact as to causation. Ms. Lewis testified she slipped and fell because the landing was wet. That's the end of story on that, whatever their expert says. But I'd just like to point out, their expert's testimony is inadmissible. First off, there's no expertise involved. He watched a surveillance video and said it looked to him like she tripped over her own foot. Well, the expert didn't have expert eyesight. He watched a video the same as you and I or any juror would. That's not expertise. Secondly, he doesn't have an opinion. He says she either fell because of the storm in progress or because she tripped over her own foot. Maybe one, maybe the other. Your Honor's prima facie is not Latin for maybe. If an expert cannot say what did cause an accident, then their testimony is inadmissible to show what didn't cause the accident. Happy to rest on our briefs unless there's any questions.
I think we're good. Thank you, counsel. Mr. Hertzler, you get 1 minute. Sorry for the printing noise.
It's okay, Your Honor. I would just say, look, if you look at the photograph that counsel pointed out at 367, he tries to say that's indoors. I mean, what matters is that it's exposed to the elements. And in cases like Salazzo, this court has made clear that cannot be considered indoors.
But what about the plans that you had to, I mean, clearly the fact that, I mean, you can make the argument about a lobby, right? People bring in snow in their boots and in their shoes, so it winds up getting wet. That's why you throw a rug. But here you also had a plan. I mean, it is an exterior landing, but I hear Mr. De La Carpini arguing that it's exposed to the element and you have a plan to make sure that the slipperiness of it is addressed. Hence why you have the plan.
Your Honor, to that I respond with this court's decision in Salazzo, where the defendant had a plan. In that case, it was a transit authority, and they had the plan to put rugs down. And this court said that's not enough, because you have to have, in order to raise a question of fact, you would need either a prior accident or a prior complaint. Just the fact of putting rugs down does not create a question of fact under numerous cases that follow Salazzo. So this court, it's totally contrary to this court's precedent. And, you know, which clearly say there's no obligation to place rugs in any, especially
what about the exterior versus the interior aspect of it?
Well, in Salazzo, the accident happened in a train station where it was exposed to the elements in the sense that there's no door. And this is even, our position here is even stronger than that, because, you know, that was the subway platform. Here, it's way more exposed to the elements than a subway platform. Okay, so it's right where all the wind and snow are blowing right in. So as the precedents that we cite in our brief make very clear, in order to raise a question of fact on this theory, which by the way was never pled, as I mentioned earlier, but there would have to be an accident or a prior complaint. And here we have 3 witnesses who all say there was no prior accident and no prior complaint. And so it's not enough for them to say, you had a plan. And by the way, in a defendant's policy is not enough to raise a question of fact if it's contrary to law, as it is here. And we cite case law on that in our brief on that. And the whole idea about constructive notice, well, an ongoing snowstorm. This was a 5-inch snowstorm. We have constructive notice. I mean, to go out there and keep on cleaning.
Yeah, I mean, your time ran out, but you are breaking down. So why don't we end it here?
Okay, Your Honor. Their constructive notice claim is contrary to the storm in progress doctrine.
Got it.
Thank you for listening.
Thank you both. People versus Hickman.
Yes, good afternoon, Your Honor. Jan Hoth for Appellant Dimmel Hickman. May I proceed?
Good afternoon, Ms. Hoth. Yes, you may.
Thank you. The people's evidence here failed to establish that the value of the stolen merchandise under either indictment exceeded $3,000. In each case,
why isn't the testimony of Mr. Bradley from Saks and Mr. Torres from Intermix sufficient with respect to the value of the items that were taken after they saw it on the video what the items were?
Well, Your Honor, there's absolutely no evidence in the record as to how they reached the conclusion that that was the price or the value of the merchandise. The merchandise was never recovered. We have no tags. We have no receipts. We have no business records.
Mr. Bradley talked about the system that they have with the floor, right? Where the surveillance people are able to ascertain what's missing once they see the items on the video, around the surveillance video. So what do you think of that?
Well, yes, according to Bradley, the way Saks is divided is that security personnel are partnered with various departments. She was partnered with the handbag department. So she was in a position and able to ascertain what was missing. Nothing in her testimony relates to value, price, or selling, only ascertaining what was missing. So, and if we look at Mr. Torres with Intermix, it's the same thing. He's talking about cycles being run to ascertain what's missing. What's missing from the record is the connection.
Well, she says, Ms. Bradley says that she knew, she did the inventory check, right? So she knew the specific handbags that were missing. There were 3 handbags. And then she testified with respect to those bags. She said the multicolor bag was sold by Saks for $725. The silver bag was $690. And the black bag was sold, that's a lot of money, but that's a different issue, $725. So 2 of the 3 wallets sold for $490. And 1 sold for $460. So clearly she testified that the total loss to Saks was $3,500.
But where did
so why isn't that enough?
Because where is she getting those figures from? That is the very point. What you're saying is my very argument, Your Honor. She
So,
sat
counsel,
in court.
did defendant's attorney cross-examine her?
Your Honor, defendant's attorney did not preserve this issue, but that's irrelevant.
Okay, but I mean, did he even ask her what's the basis of that information?
No, he did not.
So wouldn't that if that was an issue for counsel, wouldn't that have been the way to resolve it?
In a perfect world, but Your Honor, if we're going to rely on attorneys' absence of questioning a witness to prove evidence, then that's a scary world we'd be going.
No, I mean the evidence is the testimony. Testimony is always evidence. And
But
if you
defense
don't think
counsel-
that evidence is competent, the way you challenge it is to
Yes,
cross-examine,
but
right?
defense counsel not recognizing that the absence of any foundation for the conclusion as to price does not suffice to say that there was sufficient evidence of price, is my point. That is the argument. These witnesses gave a price, and my argument is that they gave no foundation, no basis for their conclusion that those were the prices. There is nothing in the evidence. In fact, my adversary in her brief says common sense dictates that those were the prices because they are charged with protecting the store's property. But they're charged with protecting all property. It doesn't matter what the price is. That doesn't indicate they would have a knowledge of the price of a specific bag. They're not salespeople. It's not like she was selling them every day and could testify, well, I just sold a bag yesterday that cost $7.55. The security personnel, knowing the price of every item in the store is not a part of their job. It is not common sense.
But she did testify about her relationship with the floor. She did the inventory check. So she laid a foundation for one, knowing what items were missing, and two, what the value of those items were.
I have to disagree, Your Honor. She laid the foundation for knowing what items were missing, whether in fact those are the items that went missing in this incident. Even the trial judge realized and the DA realized that the video was not clear as at least to one of the wallets. But regardless of all of that, her foundation, as Torres's foundation, is this is what we ascertained was missing. There is no foundation or basis for where they arrived at the price of the missing. I'm not saying that that evidence didn't exist out there. I'm saying the people didn't bring it and present it.
Okay, thank you, Ms. Hoth. Let me hear from the people.
Good afternoon, Your Honors. Emily Galt for the people. May I proceed?
You may.
So at trial, the evidence was legally sufficient and proved that defendant stole $3,580 worth of designer handbags and wallets.
So what is the source? What is the source of Ms. Bradley's knowledge of the value of the property?
Ms. Bradley testified that she was a direct partner with the handbag department, so she had specific knowledge of the merchandise specifically stocked in that area. She testified that she watched the surveillance video. She checked the sales floor. She compared what was taken in the surveillance video to what was on the floor, and she checked the SAC6 system to determine whether or not those items were purchased. She also testified that Saks is a high-end luxury store. It carries designer merchandise. These are designer bags. They were made by MCM, the wallets and the handbags. And as to intermix, very similar.
Well, Ms. Hoth, before you get into Mr. Torres, I mean, Ms. Hoth seems to be suggesting that the video is not dispositive. Neither is the inventory check, because those items could have been taken by, say, an employee. And in as much as the video is not clear about the specific items, like the wallets, for example, it's not clear that the wallets were taken in that instance. The wallets could have been taken by someone else other than the defendant. What do you say to that?
So my understanding is that the only thing being contested on appeal is the actual value of the merchandise, not what was stolen. Defendant doesn't seem to be contesting that 3 handbags and 3 wallets were not stolen. He's simply contesting that the price of each item was missing. So in regards to that, there is case law.
With respect to that, what Ms. Hoth seems to be saying is that the fact that they are security people and that they indicated that they are aware of what items are in the department doesn't mean they're aware of what the items cost. And there's nothing to indicate how they would have knowledge of that. Inventory is usually how many things are there, not how much each of the things is. I don't know. I don't believe there's testimony that says we have knowledge of how much this is because we had to take classes on how much each of these things are worth, or, you know, we we looked at the bags and we saw the price tag. I mean, what is there? What is the basis of the security people's knowledge of the price of the items that they inventoried?
So I know specifically for Intermix, there was a police report filed that stated the exact prices of the jackets that were stolen when Fernandez Torres, who was the director of loss prevention for all Intermix stores, which I think there's about 36 stores, he testified. At first, he said, I think the jackets were the mackage coats were $1,600. And then the prosecutor said, will anything refresh your recollection? So then they pulled out a police report that stated the exact prices that were submitted on the police report from the cycle count that was conducted. And the cycle count involved looking at the inventory on hand to compared it to what was stolen. So there were specific prices on the police report. As for Saks, I don't recall there being a police report with the specific prices, but she did testify the exact prices for the specific handbags. She testified that one was a limited edition handbag. And I believe the basis of her knowledge just came from being a direct partner with the handbag department. And case law does say that the jury just needs a reasonable basis to infer rather than merely speculate that the threshold has been met. And I think given the testimony that these were two high-end stores selling designer merchandise was stolen, multiple items were stolen. That, I believe, is what gives it what I reference as common sense that the threshold was met.
Thank you, Ms. Gold.
Thank you.
Ms. Hall?
Yes, I would just like to point out that my adversary was unable to point to a single word of testimony that indicated the basis for the knowledge of the price of these items. With respect to the police report, Mr. Torres used that report to—
Ms. Hall, isn't that— yeah.
Evidence. That report was never admitted into evidence. It may have supplied the necessary nexus, but it was only used to refresh his recollection. So again, that it's a luxury store, that there are high-end items. There's nothing in this record that supports the conclusions of these two witnesses as to the prices they testified to. And I did not hear anything from my adversary that said otherwise.
But that goes, the admissibility of the testimony of Ms. Bradley with respect to the value of the bags and the other items goes to the weight that the court should give the testimony, right? Not the admissibility. I mean, that we go back to what Judge Carpula says about, I mean, she could have been asked for the basis of that knowledge, and counsel should have dig in about whether she had.
Well, Your Honor, in the first instance, it is the people's burden to establish the value, and it is their burden to establish it by admissible evidence. Here we have two lay witnesses, not experts, opining as to the value of property.
I don't think that's fair to say. I think Ms. Bradley says she knew the value of it, and she knew it from being from working at Saks, involving security. She had a partnership. I mean, that was the testimony, and Ms.
That was her testimony as to why she knew what was missing. She never said that was how she knew that was the value. She never said it.
All right, thank you. Thank you both. Favorite limited.
May it please the court, my name is Sean Kemp, and I'm appearing on behalf of appellants Benedetto Chico and Carla Chico. May I proceed?
You may proceed, counsel.
Thank you, Your Honor. The trial court abused its discretion when it granted respondents leave to file a third amended complaint and dismissed appellants' counterclaims in their entirety. By decision in order dated March 3rd, 2020, this court, the First Department, dismissed respondent's second amended complaint for lack of standing or capacity to sue because a member lacked authority to obtain a certificate of revival for plaintiff Upper East Side Suites. In reaching this conclusion, the court noted that the company's operating agreement expressly stated, no member as a member shall have the right to bind the company in dealings with third parties, and no member is an agent of the company solely by virtue of being a member, and no member has authority to act for the company solely. Despite this holding, a different individual holding himself out as a member of Upper East Side Suites, Mr. Claudio Gatelli, went and refiled a certificate of revival on December 11th, 2020, with the Delaware Secretary of State. Here again, however, Mr. Gatelli was acting in violation of the company's operating agreement since he was attempting to act as an agent of the company. Therefore, this filing should have been
Mr.
deemed
Kemp, let me
null and
interrupt just
void.
for a sec. What would have been the proper way to obtain a certificate of revival in your view?
In my view, Your Honor, I think that the proper way would have been to have managers appointed in accordance with the terms of the operating agreement. I think that a lot of the genesis for a lot of the issues that we're dealing with today are the trial court's previous holding that unilaterally transformed what was a manager-managed entity into a member-managed entity. Okay, and by doing so, they disregarded the express terms of the operating agreement and kind of just, rewrote that agreement. So now it's supposedly, in the trial court's eyes, a member-managed entity. But if it was even if it was a member-managed entity.
Isn't that because the managers were the brother and sister or something to that effect, and that someone else couldn't be appointed the manager? I mean, didn't they have to then, if my memory serves me correctly, didn't they have to end up being a member-managed entity?
No, Your Honor, no, they didn't have to become a member-managed entity. There are provisions in the operating agreement where a new manager or managers could be appointed. There's some assertions by plaintiffs that there is basically a stalemate because of the ownership interest that the Chicos have that would prevent a new manager being appointed. But it was never even attempted to appoint a new manager properly, at least.
I think it was rather difficult for a manager to be appointed. That's why after the Chicos were the managers. I think that's why they sought to get the member managed entity.
That may be the case, and that is similar, I guess, similar in a way to the reasoning of the trial court that this was the only thing that could happen, right? We can't appoint new managers, so it makes sense to have this transformed into a member-managed company and have the members, handle the day-to-day business. Unfortunately, however, that flies in the face of Delaware law. Delaware law is pretty clear, and New York law is clear as well with respect to LLCs being creatures of contract. And the operating agreement, which all these members signed on to, should be the thing that dictates how this entity is operated. However, the trial court's holding by transforming it from a manager-managed company automatically into a member-managed company completely disregarded those terms. If there was such an impasse, then the relief would have been to go into Delaware, either have a receiver appointed or, commence a dissolution proceeding.
Okay, thank you, Mr. Kent. Let me hear from the respondent.
Okay.
Thank you, Your Honors. Peter Jacob from the Fine and Jacob firm for the respondent plaintiffs. May I proceed?
You may.
There are two things before the court, the motion to amend and the motion to dismiss the counterclaims. The motion to amend, we begin with the court's 2020 decision, this court's decision. It was a non-merits dismissal. It was based on lack of capacity to sue.
It was a dismissal. It was a dismissal of the complaint, and it was the order of dismissal was filed. It was entered. It was. So how then is there any complaint to amend?
The dismissal was a non-merits dismissal, and non-merits dismissals are dismissals.
There was no standing. The dismissal was because there was no standing. It was dismissed for no standing.
Correct. A very curable defect that gets cured all the time.
It can be cured. Well, I don't know that defect can be cured. It certainly could have been a new action filed, and then you would have had an opportunity within the 6 months of the order to file your new action with a new complaint. I'm not quite sure why you think once there's an order of dismissal that can just be ignored. Doesn't that mean something when there's an order of dismissal?
Of course it does, Your Honor. Orders of dismissal come down every day. Motions to dismiss are granted and leave to amend are granted following grants of motions to dismiss. This happens routinely all the time. There is nothing unusual about a grant of a motion to dismiss, which is what took place here. It was a non-merits dismissal, so it's without prejudice. And then it's to the sound discretion of the trial court how to proceed from there. One option is to amend the complaint. In this case, we've been at it for 5 years, and there's a lot of stuff that has happened in this case that the trial court has presided over. The trial court exercised its discretion to allow us to proceed by amending the complaint.
Where was the appellate division, Mr. Jacob? Was the appellate division? Did we give you leave to file an amended complaint? Were we required to do so? Because all I read in the order is that it needed to be entered. I agree that it wasn't a merit decision. So what do you say to that?
Yes, the rule is, and it's cited numerous times in our brief, that a non-merits decision is presumed to be without prejudice. A decision without prejudice may be amended. Non-merits decisions.
Wait a second, you're saying any counsel, this is Judge Scarpullo, you're saying that anytime you have a non-merits decision, 10 years later can move to amend the complaint?
Oh, 10 years later, I don't know about those facts, but
when does that stop? That's what I'm saying. Isn't the response that you should have made a motion to amend in response to the motion to dismiss? You didn't do that. The case was dismissed. You let the 6 months go by, right? You let the CPLR extension go by, and then you made a motion to amend later. Isn't that? Well, you're shaking your head. What about that recitation is incorrect?
The motion that was before the court on its prior decision was a motion to amend. It was a motion to amend. It was a motion to file the second amended complaint. The court granted that motion. That's what was appealed. This court held that it should not have been granted that motion to amend, but rather there was no standing at the time because of the issues we've been discussing. We then went right after this court's decision to the Delaware Secretary of State. We went ahead and nullified the original, filed a new, and then proceeded for the very same relief that we tried to get the first time.
And also, counsel, is it correct to say that the case was still alive because there were still counterclaims?
Of course, the case is still alive, sure. There's more claims than the ones that were dismissed. So yes, the case has been going on for 5 years. There's a lot going on in the case. The two commercial division justices have done a lot of work in the case and have managed it to the point where just depositions are left. And I'm certain that that's what went into the provident exercise of discretion that granted this motion to amend.
I see. I thought something else had happened. I thought there was a motion to dismiss, not a motion to amend. I apologize. Okay.
Well, I'm sorry. On the prior appeal before this court, we dismissed when the only thing that was before us was review of a motion to amend?
No, that's not right.
No, Your Honor. There was a motion to dismiss.
So what I said, what motion?
The counter, the cross motion that we filed in response to that was the motion to amend.
Okay.
So there
was a motion to dismiss.
And that was granted by this court. The motion to dismiss was granted by this court.
Correct. It was a non-merits dismissal that we then went and cured the defect that the court identified. We came into compliance with the court's decision, and then we moved for the very same relief we were asking for at the time, an amended complaint, this time reciting the new revival of the company.
So the second amended complaint was dismissed, and the complaint, so the complaint was dismissed. That was the request from the CEROs, from the defendants, and that was because there was no standing what this court ordered. So the plaintiff's complaint was gone. The complaint, the second amended complaint, that's all there was. It was gone. So the only thing that existed was the defendant's case, right? Because they had a.
Yes, but I don't know what Your Honor means by gone, but it was dismissed without prejudice. Without prejudice means you can go and cure it and try to proceed.
What it means is that you can go after that order, you can go and start a new complaint within the 6 months, within 6 months.
Well, we applied to the trial court for the right to amend, and the trial court.
You moved to amend. You
Correct.
didn't move to file a new complaint. You didn't move with a new action. That's not what you did. And then to join the existing defendant's action. You didn't do that.
The cases I cited in the brief show that this is a question that's directed to the discretion of the trial court. How to proceed after a non-merits dismissal followed by a cure. How to proceed. It was in the trial court's exercise of discretion that this is the best way to proceed. If the trial court had denied.
I don't know what there is to cure after the complaint, the second amended complaint. The complaint is gone. So I don't know what there is to cure. I see that there's a new action,
but you're saying it's gone not on the merits. Is that
what's to cure is the standing issue, the capacity to sue issue that the court.
Let me hear from the other side, and then you get a minute rebuttal.
Thank you, Your Honor. I think the cases that respondents rely on actually are cases where either the leave to file an amended pleading is granted in the order, or there's actually a pleading pending before the court that could be amended. And here we have neither of those. But I think the bigger problem here is the fact that the standing issue was not really cured. What the respondents are relying on is essentially dicta in this court's March 3rd, 2020 order, where it says, even if the company has become a member-managed LLC, which we are not deciding, the record contains no decision by more than 50% of the members to revive the company before April 19th, 2018. And I think that what the respondents went and did was said, okay, well, since we are a member-managed company, let's just go refile the same exact document. There's no further resolution saying that this document could be filed by Mr. Gattelli if it is in fact a member-managed company. They want to rely on this resolution from June 30th, 2018 that relates to the prosecution of the second amended complaint, not a third amended complaint, not anything to do with standing, but they basically have taken that resolution or relying on that to hijack the company, change it from a manager-managed company to a member-managed company, and then just do whatever they want in derogation of the express terms of the operating agreement. So at the end of the day, the standing issue hasn't been cured. The capacity to sue issue hasn't been cured. There was no pleading that could be amended before the trial court. And I think what the appellants would really like this court to do is rule on whether or not a Delaware limited liability company that has an operating agreement that expressly states that it's a manager-managed entity can somehow be transformed just because there's an impasse into a member-managed company. And I don't think that that's accurate. I don't think that's supported under Delaware law, and I don't think it's supported under New York law. But right now, there's a trial court.
But isn't the legality of that or the propriety of that based on the LLC agreement something that should be done on the merits rather than through a decision not on the merits, but especially if the whole issue has been cured?
Well, that's a very good question, Your Honor, and that brings us into the dismissal of the appellant's counterclaims, right? Because what the trial court did in dismissing the appellant's counterclaims was rely on their holding that said, in response to our motion, our previous motion to dismiss, the trial court said, many of your claims pertain to whether or not this is a member managed or managed LLC. We've already ruled on that. So your claim should be dismissed. I agree. If we're going to talk about merits, then our claim shouldn't have been dismissed. Our counterclaim shouldn't have been dismissed, right? At the very least. But I think that it's such a threshold issue, Your Honor, in order for us to get past go, that it should be determined here. I mean, it's a question of law.
Okay.
So wait a second, let me just clarify one thing. Are you saying that even if it was proper to allow the amendment, this particular amendment was palpably improper, and therefore we should reverse on that ground in any event?
Your Honor, I'm saying that all things considered, if this was just a typical amended pleading, the reason why it's palpably improper is because the deficiency wasn't cured.
Okay, I'm just trying to make sure that that's your
yeah, it
argument.
suffers.
Okay.
The proposed pleading suffers from the same deficiency that existed when this court dismissed the complaint, the second amended complaint, pursuant to its order on March 3rd, 2020.
And we would only have to reach that if we found that it was proper to amend the complaint to start with. Okay, thanks.
Correct.
Okay, thank you.
Thank you, Your
Thank
Honors.
you both.
Thank you very much.
Okay. Rodriguez versus Morel. I guess that's submitted in as much as one of the parties was not present, so that's submitted. Mr. Pollack, tell me who you're representing. You muted, Mr. Pollack.
I apologize. I don't believe you've called my case yet. I represent DOE for Summit versus Department of Education.
Okay, so that's the next case. Okay, so Rodriguez versus Morel is submitted. Now the next one is Summit Restaurant versus New York City DOE. You jumped the gun, Mr. Pollack. Okay, let me hear from Appellant Summit Restaurant.
Your Honor, Robert Laridola, ready to proceed, Your Honor?
You may proceed, counsel.
Thank you. Your Honor, just want to make sure I'm on. Your Honor, thank you. Your Honor, it should be noted in this case that the Department of Education chose to declare Summit in default on February 14, 2011. Draft letters shown by the DOE considered as early as December 2011 described a 30-day termination letter. They elected not to do that. That's Exhibit A233. By choosing to default Summit was forced to work without pay until June of 2012. The DOE then applied a liquidated damages provision for the entire time period of 4.5 months. This is a very similar scenario to Prada USA v. 724 Fifth Owner, where the tenant was not permitted to benefit from the liquidated damage provision where they caused their own harm. Judge Barak held that Prada could not surrender its tenancy and get the benefit of a $500,000 liquidated damages penalty. This is important and very similar because Judge Barak.
So that you're not arguing that the liquidated damages clause is an unenforceable penalty. Your argument is different, right? That basically DOE is getting double recovery since they never paid the plaintiffs in the first place.
That's the math argument, Your Honor. Yes, there is a math error here. Judge Barak just simply forgot to give credit to the $966,000 that the DOE is holding in the math. That's very clear. It's on A247. The judge calculated the DOE damages as $825,000. It should have been zeroed out completely. The interest of $645,000, which is the rest of their judgment, which adds up to 1.47 million, should have been zero because the DOE was holding the money. So why would we apply interest when the DOE is holding the money and the number of dollars that they're holding completely wipes out the liquidated damages argument? But Your Honor, that the math argument is certainly an argument that can get this matter reversed. But we are challenging the violation both under the liquidated damages clause, Your Honor. The result is disproportional. The liquidated damages clause is meant to have vendors work promptly to complete their jobs. It's not meant to be damages in a default scenario where the contractor languishes on for months waiting for the process to go through. So $100 a day liquidated damages fee for late performance of a task like sharpening a blade may work if the contractor's in place, but the damages here, the measure of the damages is what is the harm to the city by the replacement contractors. It's readily calculable. As a matter of fact, they estimated it at $450,000.
Well, but again, you're not complaining about the $100. I mean, it's clear that to the DOE, time was of the essence, right? That you're talking about the machines that are basically used to serve children in the school system. So you know, when they bargain for an expedition resolution or fixing of any problems with those machines, you know, they expected you to do it pursuant to the terms of the contract. So $100 a day doesn't sound like an enforceable penalty. Your argument again is something different, right?
Well, Your Honor, we're arguing the math as you exactly described, but we are actually arguing that this particular clause had a problem with it. This is the first time that this has been used with this new FAMS computer system. And what happened was that there was a screen that you had to use to upload a letter before you could ask for a waiver of a penalty. That waiver issue became a real problem on this contract because do you need a letter from a manufacturer or do you need a letter from a vendor? Well, for months, my client had to go to the manufacturer.
Well, what did the contract say?
The contract said that a manufacturer's letter was only required in the event that there was a manufacturing problem. An email from Ina Pradnikov tried to change that to say it was required in all cases where whenever you wanted to waive. So that caused a lot of headaches, but they fixed that in the later version of the contract. They changed the language. So we think that there actually are problems with this liquidated damages clause, Your Honor, and it's the clause itself that's yielded the problem to my client. They really should have looked at the cost to complete the job and not the liquidated damages penalty as a measure of damages.
Okay. Thank you, counsel. Let me hear from DOE. You're muted, Mr. Pollack.
I apologize. I'm still adjusting. Good afternoon, Your Honors. Ben Pollack for the Department of Education. May I proceed? You
may proceed.
Thank you, Your Honor. This court should affirm because all of Summit's claims are barred by claim preclusion. And in fact, every single argument this court has heard this afternoon from my adversaries have stopped from making those arguments. We have demonstrated in our response brief that the contract very clearly required, and in fact, Justice Velasquez's 2012 order likewise required Summit to bring every dispute before the dispute resolution officer. Now, Summit did so, and the dispute resolution officer, the DRO, issued a decision on the matter of Summit's hundreds of in fact, thousands of violations of the contract's time requirements, the propriety of DOE's assessment of liquidated damages, and DOE's ability to declare Summit in default of the contract. Now, this decision was only reviewable by an Article 78 proceeding, which Summit in fact brought. When Summit stipulated to discontinue its Article 78 with prejudice and without any reservation of rights, the DRO's decision became final, conclusive, and binding. Summit may not now attempt to relitigate claims.
Well, Mr. Pollack, but doesn't that assume that submission of these items for dispute resolution process that led to the DRO's determination was valid in the first place. And really, the argument with respect to whether you waived your right to dispute resolution by basically participating in this litigation for a 7-year period.
Yes, Your Honor. So my adversary has argued, as you pointed out, that DOE waived the dispute resolution process. But as Your Honors may have noticed, in Summit's reply, Summit only argues that DOE waived the DRO process as to the termination claim. However, that's not the claim the Summit is focusing on here. Summit is focusing on every other claim besides termination, and Summit has not disputed that those claims are all barred. They're all stopped. Now, as to waiver, there's a fundamental flaw in Summit's waiver argument, which is that DOE participated fully in the DRO process. They went before the dispute resolution officer and participated in it. And then on top of that, when Summit improperly brought
DOE or Summit Restaurant?
Pardon me?
Who participated fully in the DRO process?
Both parties did.
Okay.
Honor. And not only did DOE fully participate in the dispute that Summit brought, but DOE also raised the dispute resolution process as a defense in 2012 in its response to Summit's summons and complaint. Now, Summit has been engaging...
So, counsel, that's what I'm saying. 2012, you raise it. You never bring a motion to dismiss on that or a motion for summary judgment, correct?
That's correct, Your Honor.
You do discovery in the action, correct? Yes or no?
Long response, Your Honor. I sense that there's a list here.
I'm just asking you, did you respond to discovery demands?
Your Honor, we did.
So, I mean, I can say that the sky is blue, but if I'm acting in every possible way, like the sky is green, kind of, doesn't really fly so well. So again, I ask you, did you produce discovery in the action?
Your Honor, the question...
It's a pretty simple question.
Respectfully, the procedural history here is very complex because there were two actions that Justice Ramos was hearing together. There was an Article 78 action, which was proper under the contract, and that was the Article 78 challenge, which Summit discontinued with prejudice.
I'm asking not about the Article 78 because I agree that's part of the proceeding. I'm asking about the straight up plenary action. Did you respond to discovery requests in that action?
Respectfully, Your Honor, discovery was for both actions, even though...
Okay, so the answer is sort of, kind of, yes. Even though you asserted the defense of alternative dispute resolution in the entire time you were litigating both actions, not just one, never made a motion to dismiss or for summary judgment, correct?
Correct, Your Honor. However,
that's pretty tough from you to come back from. Let's agree. Those facts are pretty tough for you to come back from.
Respectfully, Your Honor, I really disagree because the Article 78 was proper and Justice Ramos ordered discovery for both the Article 78 and for this plenary action, and it was the same discovery.
But you never said to Justice Ramos, I don't have to do that action. I only have to do the Article 78, correct? And when plaintiff agreed to discontinue the Article 78, you signed that stipulation, correct? You didn't say, because what the plaintiff says is we all agreed that those claims were covered in the action. You didn't say anything about no. If once this Article 78 goes, you are done in court. Did you raise that issue at any time? You signed that stipulation, correct?
Your Honor, it was not DOE's responsibility to manage.
I'm just asking you whether you signed the stipulation. Yes?
Did we, I believe Your Honor is asking, did we counsel Summit on the wisdom of their action in stipulating.
Now, what I'm asking you is, did you sign a stipulation in which the parties agreed that that would be, that action would be done because those claims were covered in the other action?
Yes, Your Honor, we did stipulate to discontinue the Article 70.
Okay.
Did you ever ask for a stay of this action so that all claims that were covered under your contractual ADR provision could be handled in that fashion?
I don't believe the record contains any evidence of that, Your Honor.
Okay.
However, as I mentioned, throughout the course of this proceedings, DOE did raise the dispute resolution process as an affirmative defense. And further, Your Honors, the waiver argument does not apply to claims that received a final binding and conclusive determination. And this court, New York courts, as has long been recognized, employ a transactional analysis approach to claim determination. Now, again, it's undisputed at this point in the proceedings that every claim except for termination has received a final and binding determination. No additional determination is proper or is possible for those.
Thank you, Mr. Paula. Mr. Rodola?
Your Honor, there's no discovery.
This is usually the time where you say, thank you, any questions? And be done, right?
Your Honor, I just want to say that there's no discovery in the Article 78 proceeding. Of course, it was all in the plenary action. There were tons of motions, tons of discovery, subpoenas, electronic discovery done and redone that the city got the benefit of. They rolled the dice here, got the plenary action on their side, and got our action thrown out. They got the benefit of this this Article 78. The Article 78 DRO never had termination before her. She only had 900 tickets before her. And they redid the same tickets that were for the DRO in my case in the plenary action. They did not accept the DRO's decision. They added to her damages. So, any questions, anyone?
Sir, is there any piece or component or portion of the DRO's findings that you agree has preclusive effect in this action?
I think that had the DRO's, the answer respectfully is no, because the very same tickets that the DRO reviewed were added, if you look at the exhibits, in their damages that are now before the 1.4
Right, so they so all of those tickets are part and parcel of this litigation.
Yes, and they even added more money to the same tickets in this case.
Okay, thank you. Thank you both.
Thank you for the questions.
Resnick Seaport.
May it please the court, Henry Masha for the plaintiff, Resnick Seaport LLC.
You may proceed, Mr. Masha.
Thank you. Supreme Court should have granted plaintiff's motion for summary judgment against the defendant guarantor. There's no dispute that the guarantor agreed to pay any shortfalls of rent owed by the tenant. And there's also no dispute that the tenant missed certain rent payments. In support of our motion, we submitted a rent ledger and an affidavit from our principal, and we even submitted emails from the tenant admitting that there were rental arrears. The only dispute here is about what rent is owed. And on that score, our position is that the Fourth Amendment lease agreement is binding, it's clear and unambiguous about the rent that's owed. To avoid the consequences of this agreement, the guarantor relies on certain legal arguments, three legal arguments, but none of them has merit. The first is that there's an oral modification to the Fourth Amendment lease agreement. That's defendant's primary argument on appeal. And there's three reasons why that argument should be rejected. The first is that it's not preserved for appellate review. That was not the defendant's theory at the motion court. Their theory was that the Fifth Amendment lease agreement, which was unsigned, was enforceable.
Mr. Masha, can you focus on the email exchange and whether that satisfies the statute of frauds?
Absolutely. Well, it doesn't satisfy the statute of frauds because it doesn't contain the material terms for an enforceable agreement. The tenant in this case asked for a temporary rent reduction on a lease that was enforceable until 2026. And the tenant also said that after the temporary rent reduction period, the rent would go back up but it wouldn't be as high as the rent that he was paying now. That was the tenant's proposal. But none of the writings contain any statement about how long this rent reduction period would last, when it would end, or what the rent would be at the end of that rent reduction period. And those are material terms. You can't have an enforceable agreement that's missing such critical terms.
Counsel, you'd concede that the rent reduction period did commence and that the first check was paid for $20,000, correct?
We don't concede that the rent reduction period commenced.
Well, did you protest this check for $20,000 that you received in whatever it was, June or July 2018?
We didn't contest it, but the lease, in Article 24, and that's page 11 of the record, allows us to accept less rent than is required under the lease without waiving any rights. That was the landlord's prerogative, and that's what we did. At most, accepting the lower amount of rent was a preparatory step taken with view toward ultimately consummating the Fifth Amended Lease Agreement. And the parties never consummated that agreement for a variety of reasons. For one, being that the tenant didn't even pay the reduced amount that they proposed on time. And on top of that, they had...
After that payment of that $20,000, then there was an email where the where the tenant said what the total amount was, and said that the payment of the $31,000 now per the agreement was reduced to $20,000. And after that, they continued to pay the $20,000. You accepted that money without objection, and then in following emails after that, the plaintiff, the landlord never indicated that the tenant would owe more than $20,000, that it paid each month for the base rent. So why isn't that, why don't those emails support the defendant's position now that you agreed to accept that fixed rent of $20,000? I mean, and then it was in November 2018 email, the plaintiff, your client, indicated that the tenant had failed to pay a $1,000 water charge, but it didn't say anything about, the fact that, oh, you didn't pay the $1,000 water charge, and by the way, you only paid $20,000, not $31,900 or whatever it was. It just
the lease permitted you.
Right, the lease allowed us.
The lease permitted you to do it as long as you claim, to accept it without prejudice. And you didn't, so you can take it on the protest, as Justice Renwick suggested, but you didn't do any of that. You just took the $20,000 and moved on.
Yeah, because those were preparatory steps toward consummating the final agreement, which was never signed and it was never complied with. So that's what those acceptance of those rent payments is. We were accepting those in anticipation that the parties would come to an agreement, and we never did for a variety of reasons. One of them being that even the payments that were made were late. Another reason being that the tenant continued to accumulate fire department violations. They failed to attend hearings. In February of 2019, they accrued 4 more violations, which totaled about $30,000. So we had the right to accept less than rent than we were owed under the agreement. That was our prerogative.
You do, as long as you don't take the check without mentioning any prejudice. I mean, you are allowed to take it. I agree, the lease permits you. But the question is whether the emails with the reduced amount contain all of the elements that satisfy the statute of frauds, right? So the requested reduction is there. So we were talking about $20,000 in June of 2018. You accepted the $20,000 without protest, without any indication that was a problem, and you accepted it thereafter without objection. That wasn't the only check. You accepted other checks.
Absolutely. There's 2 responses to that. The first one is that we accepted it because we anticipated coming to an agreement, and the agreement never happened. The second thing is, even if you think that we could be obligated for that $20,000, there's no indication of how long that would last. and the tenant accepted a temporary reduction, and we don't, and so that.
So let me counsel this is Judge Scarpula. Is there any indication you sent a draft modification and said, here
Right.
it is, 20 grand. But is there anything in that email that says, but we haven't decided how long? It said, look it over. As long as the numbers are good, sign it. That's what it says. It says nothing about, and by the way, this is only going to last 3 months, or by the way, it's only going to, I mean, you literally attached a proposed modified lease.
Absolutely.
So to me, you're saying now we hadn't agreed to everything doesn't jibe with what the documents say.
Well, but that's a different argument. If the argument is now that the Fifth Amended Lease Agreement is binding, that's very different. I mean, we repeatedly told the tenant that this would not be binding until everybody signed it. That was on, and that's on page 234.
The question is there enough of if there are enough writings to satisfy the statute of fraud? And you're saying there aren't because there are material terms missing. And I'm saying that doesn't fly in the face of you sending a proposed agreement that, and with nothing that says anything about any term left to be negotiated.
Well,
Similar
Judge,
as if we had a MOU or an LOI. This is what I am saying to you. Whether or not at the end of the day, it's a binding agreement.
Right, that's for the trial courts to decide, right?
The question is, you said this is not good under the statute of frauds.
I'm saying that the argument about an oral modification isn't enough. If the argument is about the Fifth Amendment,
it's not an oral modification because in Bistro, for example, we accepted emails as binding, as a writing, particularly when you have the name of the parties at the bottom of it.
Right. So there's two responses to that. One of them is, even if you accept the Fifth Amended Lease Agreement as a writing, they didn't even comply with that. They still paid their rent late, and they weren't in compliance with the lease.
Okay, that's a triable issue.
Hold on. But if that's a triable issue, then the proper response would be to reverse the Supreme Court order and grant a summary judgment on liability, because there is no dispute that the tenant had over $50,000 in rent arrears that accrued before the rent reduction, and they didn't pay any rent from June to December. So there's no question that the guarantor is liable. The only question is about damages. So then if that's the case, we should get a summary judgment on liability and it should be sent back for damages.
Let me hear from the other side.
Your only argument. Your argument was, argument was there's no agreement. So that's.
I maintain that that's our argument. I maintain that that's our argument.
Your argument was never, they owe less than what we say they were.
Oh, sure. We said that throughout. Absolutely. We said that throughout
the act. Just letting the trial judge do that.
Well, Judge, respectfully, I disagree with that. Throughout the motion practice, we said that the only dispute is about the amount and not about liability.
Okay, let me hear from the other side.
Thank you, Your Honor. For the respondent, Nativ Winiarski, there was an argument this morning, Curtis versus Marino, which counsel for the appellant said context matters. Nowhere is that more applicable than in this case, where context matters, where if you look what happened in June 2018, you have the defendant, who is the guarantor on the lease, who's looking to limit his liability, set forth in very clear, transparent, and sobering terms to the landlord saying, look, I get all of my business from the tenants in this building. Your building is operating at less than 50% occupancy at this point, and you're just losing a major tenant, AON Insurance. Therefore, I cannot continue to pay $31,900, and I am looking to limit my liability. However, if you want me to stay, then I will agree to pay a $20,000 reduced rent. And the landlord, looking to attract further tenants and have this restaurant stay on the ground floor, says, you got yourself a deal. And yes, he does say, you know what, I'm going to send you an agreement and nothing is binding. But Justice Scarpula, you said in the last argument, you can say the sky is blue, but you can act like the sky is green. And that's exactly what happened here.
No, but okay, let's assume that we all agree with that. The real question then is, why not just send it back for because you're not saying you paid the 20 grand every month, did you?
Oh, we did. We paid $20,000 from July 2018 until June 2019. We paid it for a year. They accepted it for a year. And then
okay, but then what? Then you stop paying?
Then they sent us the notice saying we want you. Well, then WeWork came in as a tenant. They no longer needed us. So they have the classic switch and bait, which is to say that I want you in at one point, but now that I don't need you, everything that we talked about in the differential, let's forget about that, right?
So you're saying so that you stopped paying after they said the lease is terminated.
That's
you
correct.
While the lease was going on, and you
We
both
pay
thought
every month.
so. Okay,
Every month.
so then that solves that issue for me. Okay.
And
So
I'm sorry, Mr. Justice Acosta.
Yeah, no. What I want to remind all of us is that we're talking about the context of summary judgment, whether we should rule as a matter of law, whether we should affirm or reverse. I mean, the court found that there were triable issues, right?
Correct.
I mean, the issues with respect to the writings, the import of the bistro case from our department, whether that was a complete writing that
Right.
you sent, Mr. Warnowski, all of these issues. So,
Well, I would submit, actually, Your Honor, that not only clearly was the lower court correct in finding an issue of fact and relying upon the bistro shop case in which Your Honor was the presiding judge in that case, but if you look at the bistro shop case, the language of the court was that the email sent memorialized the verbal agreement. The landlord acknowledged its accuracy, and so the Supreme Court properly found that the exchange constituted a written modification. I would argue
Counsel, may I interrupt you for a moment and just ask you, do you agree that there were outstanding terms that hadn't been negotiated?
No. All the terms were negotiated, and this was very simple. We're reducing the rent. We want you to stay in possession.
And everything else was the way that.
That's right. Everything else stays in place. And what was the reason for all this? Because the guarantor, the defendant, said, I want to limit my liability. And if you want me to stay, then let's agree to this reduced rent. And if not, I'll give back the keys, because the guarantee provides that if you give back the keys, the liability ends. So the landlord induces him to stay, gets his WeWork tenant who rents out 200,000 square feet of space, and now says, now I don't need you, you're gone. And so not only is your lease then terminated, but we're seeking the deficiency that accrued while we accepted the lower rent for the last year. So it's exactly as Your Honor said, Justice Scarpula. You're going to say the sky is blue, but act like the sky is green. And they acted completely in accordance with the written modification.
Okay. Thank you, Mr. Warnowski. You got 1 minute, Mr. Martian.
All right. I'd just like to also mention that not only did they not pay rent from June 2019 to December, they also had arrears that had accrued prior. So there is no dispute about that. There's over $50,000 there. And they also had violations from the fire department, which is a violation of the lease. And they didn't even comply with what they said they were going to do. They did pay the rent, but they paid it late.
Those may be the very same issues of fact that were found by Justice Guest, right?
But those are only issues about damages, not liability.
Okay, we'll see that. Thank you both.
Thank you, Your Honor.
Thank you.
Durazno versus 680 Fifth Avenue.
May it please the court, this is John Shaw for Plaintiff Appellant. May I proceed, Your Honor?
You may, Mr. Shaw. Good afternoon.
Good afternoon, Your Honors. Thank you. The lower court respectfully made several misstatements of law in this case. Very briefly, I'll touch on the Sanitas standard. One of the main prongs or focuses of their ruling was based on the mistaken fact, I have to say, that the work was for the benefit of the tenant, meaning the GAP, as opposed to the landlord. And that's a misstatement of law under the Court of Appeals Sanitas case. And that was one of the bases for its opinion. And also the court said plaintiff was responsible for his accident because he did not ask someone to hold the ladder. That's another misstatement of law under, for instance, this department's of cases, which I cited to in McCarthy and Ortiz. Then the court misinterpreted the holdings of of the Court of Appeals cases of Soto and Bragi, which actually support my client's claim.
So we agree. I don't think we need to spend a lot of time. I mean, commercial window washing does constitute cleaning under 240. That's pretty clear.
Absolutely, Your Honor, and we won't get into that because that's a given. But the court said that this was routine maintenance, and based specifically.
No, I won't spend too much time on that, Mr. Shaw. What I want you to address is the fact, because the Court of Appeals in Bragi was very clear that the crucial consideration is whether the work that's being done creates an elevation-related risk. That's really the issue. And so address yourself to that, please.
Thank you, Your Honor. Actually, Bragi supports my client's claim. The reason in Bragi that the Court of Appeals dismissed the plaintiff's cause of action was, to quote the Court of Appeals, he, meaning the plaintiff, did not testify that he required or used a ladder or a platform to reach the top of these windows with his wand and squeegee. And then the court...
Counsel, let me interrupt you there. I'm sorry. The plaintiff here said he needed the ladder to have sufficient leverage to clean the glass. But does the defendant's expert, Mr. Whitty, create an issue of triable fact saying, no, he could have done this job by using the extension pole that was available on site?
Actually, putting aside that Mr. Whitty's testimony, again, respectfully, has no relevance since he did not inspect any of the ladders, came to the site well over a year later, didn't even say if there was the right dimensions. Actually, in Mr. Whitty's own report, which is not admissible, if it's part of the record, he even says the ladder was a sufficient device. He said, well, plaintiff may
Counsel,
have needed...
Can you get to the point about the extension poles? Somebody, an employee at the site, took photos of the extension poles available on the day of the accident. One of them was 12 feet. Mr. Durazno's 5'5" or 5'6". It sounds like, let's say 5'5". And Mr. Whitty says that's enough. He could have used the pole. So therefore, there was no elevation-related risk here because he could have used the pole.
Actually, they concede in defendant's brief, and Mr. Whitty said that they could have worked on a lower level of the ladder. They even concede there was an elevation-related risk. In fact, the record is actually uncontroverted that Mr. Durazno testified that he could not have done the work without being on the ladder. No one controverts that in the record. All you get is an affidavit with a squeegee pole. We don't even know if it was the squeegee pole or the actual dimensions, but no one says that that was not an elevation-related risk. Even Mr. Whitty said that he needed a ladder at one point in his report. The only
Wait a second, counsel, this is Judge Scarpula. Didn't the expert conclude that he didn't have to get on the ladder, that he could have? I mean, I read that report. That's what I thought he concluded. So are you saying that he didn't conclude that?
He concluded that in his affidavit, but in his report, he had three scenarios. One being that he could have worked on the ground based on his inspection of the site and ladders that weren't even the ladders at the time. But he also had two other scenarios. One, he could have used the ladder with the squeegee and he also conceded that the ladder in one of his scenarios was necessary. His whole argument was that it was not a defective ladder, and he went through a whole.
Although he did not inspect the ladder, right? Because the ladder they had gotten rid of it when he examined it a year later, right? So that's the first thing. Then he says that he could have used the pole standing on the floor, but then later on he also says it could have been on the second step, from the
Exactly.
second step of the ladder.
Exactly, Your Honor. And in defendant's brief, they even concede that he could have worked on a lower level of the ladder. That's an admission and a concession that that's an elevation-related risk.
Okay.
My client was doing, this wasn't some dusting as in Soto, where it was 6 feet up, you had a 4-foot ladder. These were glass panes that were 15 feet up. It was never done. It was not some routine thing. He was at that particular store for over 3 months, and he never saw anyone doing that work. It was not some routine work, which is one of the criteria of Soto. Obviously, not dispositive. This was not something you do in your ordinary household, where you're going up and cleaning glass panes that were at least 15 feet up. And
Okay.
he also said with the ladder, he had to use the ladder. No one controverted that, to apply the pressure at page 169 of the record. And he was also doing similar glass panes, and he was specifically asked, which they relied on it, could you have done the work without the ladder? He said no, and no one controverted that.
Let me hear from the other side. I think Mrs. Sperber. Who? Tell me the other side.
Mr. Prisco.
Right. Go ahead. You counsel for 685th Avenue. You are muted, sir.
Did you hear me now, Your Honor?
I can.
Okay.
You may proceed.
So, counsel, I'm going to ask you right straight up. Are you saying that are you disputing whether or not there was an elevated related risk? Counsel for the plaintiff says you don't dispute that this is an elevated related risk.
Well, I do dispute it, Your Honor.
And you put it in affidavit from your expert?
The expert clearly affidavit indicated, based on his measurement of the ceiling height and the glass panes, that he's 5'6" tall, and he had a 12-foot extension device, which clearly it was very easy to get up to that particular area. Just like at a regular household or a commercial establishment, somebody has a 15-foot ceiling in their dining room or living room, and there's glass panes, they get up and they squeegee the windows. It's a very common thing. Plaintiff chose to, and he testified that he used the squeegee in the past, that the squeegee was available. He knew about the squeegee. He also testified that the ladder that he used in the past, that on the time of this accident, he opened up the ladder, he inspected it, he saw that it was in good condition, there was no problems with respect to the ladder. But I think the most telling part of the case, Your Honor,
but isn't that, haven't we found in the context of 240 that the fact that the ladder failed means that it was not a proper tool to conduct the work that he was assigned?
that would be correct, Your Honor, except in the Soto decision. I believe that what the plaintiff was doing at the time of this occurrence was a simple routine matter. It was a bucket with solution, putting the...
It's what he had done before, but we have already held, and the Court of Appeals held in Bragi, that this is not simple routine. This is a commercial context, and in a commercial context, this constitutes cleaning pursuant to 240. So that issue has been disposed of, right?
I do believe that the case of Torres versus St. Francis College is dispositive on this case. That was an individual on a ladder with a rag cleaning a net. We know a basketball net is 10 feet off the ground, and there's a net of 3 to 3.5 inches of the backboard. So that individual was on a ladder cleaning with a solution.
But Soto, I mean, part of the reason that Soto is not dispositive is because the 4-factor test that is laid out in Soto it applies only to the outside sphere of commercial window washing, right? So that wasn't a commercial window washing context, was it?
In this case, Your Honor, I mean, it's a retail store, so it is a commercial building. but the height that the individual was working upon, whether it was 13 to 15 feet, was not dispositive of such a height that he could not do it on his own, standing on the ground with a bucket.
But he says that he did need to be on the ladder, and he said that he had to be on the ladder to be able to get sufficient leverage. He didn't use the word leverage. He said to get sufficient force, but it's the same thing in order to clean the glass. And that is not addressed. It goes unchallenged. So why doesn't he establish through his testimony that I was the one up there, I took the ladder, I needed to be on the ladder to be able to appropriately clean this glass that was 15 feet up?
Because I believe, Your Honor, that what he was doing was routine maintenance and cleaning. It was not.
Well, let's get beyond that. Let's get beyond that. Let's assume for the purposes that it wasn't, that it's consistent with Bragi. And let's also get to the point that your expert didn't address that aspect. I mean, do you have something that suggests your expert countered that?
Well, I believe within the expert affidavit, when he went to the site, he did measurements of everything. He knew what the plaintiff's height and weight was. He knew what type of...
He got it wrong. I think the plaintiff was 5'5". He said 5'6", but in any case.
Okay, I believe in the record it was 5'6", but 5'5", 5'6". But the whole point of the matter is that he knew what the height was of the plaintiff. He knew the squeegees that were available. Plaintiff testified he was using a 12-foot squeegee at the time, and clearly that was enough to reach the area and to clean it appropriately. I mean, he was 5'6". He had to go up 13 feet. He only had to go up.
Was he given instructions or material to do the work that he refused to use? In other words, was he recalcitrant? Did he fail to do what you asked him to do for no good reason?
Well, Your Honor, I represent an absentee landlord, as the court is aware. The Gap was a tenant of mine. The Gap was the employee of the plaintiff. That is within the contents and knowledge of the Gap. The only testimony we have is with respect to the plaintiff himself, that he went to the basement, got a bucket, got the solution.
Right. Which is pretty unequivocal, right? He testified exactly what he was asked to do. He testified about what he did. And I find nothing in his testimony, having reviewed it a few times, that contradicts what happened in the case. You know, namely the nature of the work that he was doing, the tools that he needed to do that work. What I find is an expert who hasn't examined the ladder from which he fell, who's saying contradictory things. Yeah, he could have done it by stepping on the second or third step. Oh, no, he could have done it from the floor. There's other evidence about how he could have done the work, but there's nothing to... Remember, 240 is strict liability, is it not?
Yes, Your Honor.
So it's not like he contributed he contributed to it, or he's the sole proximate cause of it. There's a ladder that fell. That's quintessential 240 material, strict liability. So what's the point?
Well, Your Honor, I believe based upon the Soto decision and the four-pronged questions that the plaintiff, it's not dispositive that every question has to be answered. I think it is clear and reasonable that cleaning a glass, he cleaned not only the glass partition, he cleaned the doors and the skylights above the doors. They were also at elevated heights with his squeegee. It's essentially routine cleaning of a retail establishment, just like
we're not talking about the other areas from which he didn't fall. We don't have the evidence as to how high they were. We have this glass and we know how high it was, and no one has talked about how dirty the glass was, what he had to do to clean it, and he is the only one who said, in order to adequately, essentially what he's saying, in order to adequately clean that glass, I had to be on the ladder so that I could get the leverage I needed to clean it. In his words, so I could apply sufficient force to the glass to clean it. So I don't see that your expert, and I want you to tell me where it is if it's wrong, I don't see that your expert addresses his statements that say that's why the ladder was needed. I don't see that your expert challenged that statement in any way.
Well, I believe that the expert opined that, like I said, based upon the size of the individual, the inspection of the stick and the squeegee device, and his measurements of everything, that it's reasonable for anybody to be on the ground to utilize that to simply clean a plexiglass window.
I don't think that the stick was available that was used. Neither was the ladder. Am I correct on that?
No, the sticks were available. We got affidavits from the managers of the store and took custody of the two that were present on the day of the occurrence, and they're in my office. So the sticks are available. They were reviewed by Mr. Whitty. The plaintiff testified that they were the sticks, that he utilized the 12-foot and the other sticks. So.
Okay, thank you, Mr. Briscoe.
Thank you.
Mr. Shaw, you get 1 minute.
Yeah, thank you, Your Honor. Again, the counsel, along with its brief, again with the lower court as well, misstates the law. The fact that it's an absentee landlord is irrelevant as a matter of law in the Sanitas case. That's why I withdrew my 200 claim. But their expert, who really has no probative value in his testimony, which has been rejected on other cases by this court, in the Marino case and the Harama case, actually on page 299 of the record, because he was trying to establish that the ladder was not defective. On page 298, he went through a whole thing based on these ladders, which weren't even used at the time of the accident, that it was not a defective ladder. It's irrelevant. The ladder collapsed. We even have a video. But the expert himself on page 299 says, based upon the workplace geometry and the work that needed to be performed, a portable ladder was an appropriate device to be used in this case. Then he also says, a portable ladder in combination with an extendable pole with cleaning attachment could have been used to accomplish the work. Well, he's even conceding. He's throwing everything out there. Not a defective ladder. The ladder was fine. The ladder failed. 240.
Thank you. Thank you, Mr. Shaw. Thank you both.
Thank you.
Now, the last case is 150 East 3rd Street versus Ryan. Justice Higgett has recused. So see you in a while, Justice Higgett. Let me first hear from the petitioners in this case, 150 East 3rd Street.
Thank you, Your Honor. May it please the court, my name is Stephen Sperber. May I proceed?
You may, Mrs. Sperber. Good to see you.
Thank you. Nice to see you too. I only wish we could be in person. This appeal involves part of an appellate term decision that reversed part of the court below's decision in negating the fraud finding, but nevertheless, in this overcharge, remanded the matter for a hearing on this pre-HOSPA claim. It must be noted that the renovations in this case took place in 2006. The tenant moved in 2011. The holdover proceeding that gave rise to this claim was in 2017, many years later. Now, on the day of trial, the parties, in lieu of trial, chose to chart their course and they entered a stipulation. And because of that stipulation, I submit that there's really nothing to remand for, because look at the unrebutted facts. A, that there was a full renovation in July or August of 06. B, that in evidence are the two contractors' affidavits showing that 67,000.
Well, they don't dispute the renovation. They dispute what the value of those renovations were that got the apartment to have a rent that increased 600%, right?
Yes, Judge, but we have been taught on many occasions that challenging the cost, and Boyd is one of them, a hunch that it's too much money, that doesn't give rise to a claim. There's no.
But it wasn't a hunch, Mrs. Berber. I mean, even going back to the permit that was obtained with respect to those violations that were issued for working without a permit, even that places the value of $28,000 rather than than 18 at 18 rather than 28.
That permit, Your Honor, is just an estimate. And in fact, the Division of Housing and Community Renewal has said that those estimates are not to be considered in determining whether or not there's fraud. And when you apply for a permit, you don't include all of the extras that you're going to do, like the new flooring, like the new doors, like the brand new apartment.
Sperber, this wasn't, I thought I heard my colleague say 20-something thousand, but I thought that the amount in total was $61,340, not including an additional $6,000. That would have brought it to $67,000, which
correct.
is some 3 times the amount that DHCR suggested. So it's not about, oh, we only put in what we needed for, to get the DHCR to find that our, to get the permit or get whatever it was that had to be gotten. This was way off. I mean, way off.
No, Judge, actually, Judge Elsner only found it to be $10,000 off because you don't need a permit for much of the work that was done. You need a permit to do certain work, and the work that needed a permit was $28,000. If you read Judge Elsner's decision, she went through in detail. She broke it down into 3 categories. She found A, the $28,000 versus the 18, and then she disallowed $20,000 in costs for the demolition and for the sanding of the floors. And it's beyond dispute that when you put in new floors, you are allowed to get an increase for the sanding of those floors. That's what she disallowed. But when it's in conjunction with a total renovation, you're allowed to use those expenses. So no, Judge, respectfully, that's not the case. You didn't need a permit for all $67,000 that was.
No, but wait a second, Mr. Sperber, so your argument is the tenant stipulated that was an appropriate thing. I think the stipulation says that money was spent, not that, and I agree that wasn't, because if the tenant stipulated to that, then why would there be that? Then you're right, the proceeding would have been over before it started.
No, Judge, because the reason for that, and in fact,
right? Well, didn't you leave it? Didn't you say, okay, you spent this money, but then the judge gets to decide, was that an appropriate expense? She said this wasn't.
Is it appropriate in the context of an of an IAI? Are you allowed
and she said, no. That doesn't vitiate the stipulation. It doesn't. So what is your argument then?
Well,
that she was wrong on those disallowances?
Absolutely. She disallowed.
And then the appellate term said, send it back, agree that there's no fraud, but go back and see whether or not you agree with the disallowances, right? Isn't that exactly what happened?
No, I don't think so. And if you look at the cost that it's found at page 13 of the record, the cost that she disallowed Brazilian cherry wood flooring, for staining moldings and doors, for putting a new front door in, for 3 new wood doors, for new closet doors, for sanding the walls, and for demolition and garbage removal. And those are the things that she disallowed. Those were not permanent items. If you look, in fact, on the same page, you could see that the permanent items were $28,000. And this, Justice Renwick, goes to what you were asking, and that the estimated cost of the contractor was $18,000. That, again, is found at page 13 of the record. And so what I'm saying in support of my argument, Judge, is that she was supposed to decide if things were wrong. So, for example, if you paint an apartment—
That things were what, Mrs. Spurrier? I didn't hear
that were not allowable as an IAI. So, for example, if you take an apartment and you put new floors in, but you leave the old walls and you paint it, of course you can't get an increase for that painting. So we gave her a list of everything we did, and the judge was going to decide whether or not those were permissible to be included in the calculations. But she didn't do that. She went ahead and she made a finding of fraud, even though fraud was not pled, even though it wasn't in the stipulation, and even though—
But the appellate term said no, there's no fraud, didn't they?
They said there's no fraud. That's correct.
Okay.
And there's no cross appeal of that finding either.
But before, you said this was a case before HSTPA, right? And at that time, wasn't a tenant able to challenge the regulated status of the apartment at any time and go farther than the 4 years?
Yes, and that would be one of the reasons that we did that stipulation, because we knew coverage was an issue. So then I would submit that you look at what's in the record. So what's in the record? That this is the work that was done, that this is the amount that was spent, and there's now no fraud. Where is the rebuttal? There's nothing in this record for Mr. Price that says they didn't do this or that
There
this.
doesn't have to be, I'm confused why you keep getting hung up on fraud. There doesn't have to be fraud to say that it wasn't properly deregulated. They are saying that what the court said, what the judge said was, and you're right, I misspoke, that after looking at the amount that was given, she found that it was still, there was an amount that was not appropriate, that it was less than the amount that should have been calculated for it to be deregulated. That's what she said. Under these calculations, it shouldn't have been deregulated. Okay, so it goes to the appellate term, and the appellate term says, okay, but there's no fraud there. It was the wrong amount for deregulation, so it shouldn't have been deregulated. This apartment should be a regulated apartment, but there's no fraud. I'm not clear on what you're saying. I mean, let's look at it that way. There's no fraud, but it should have been deregulated. It should not have been deregulated.
The rent, and that's why I think the court went over saying basically that you failed to justify the rent of the 1,683 increase in rent due to the IAA in 2006. That increase basically was only supported by the 2 affidavits from the contractors that went back, for work done 10 years before.
Right. Because the owners were told all along that you only had to keep records for 4 years. And because when we tried to get the records from the bank, we couldn't get the records to show the checks. So we brought the contractor to court, and instead we did the stipulation, and he submitted that affidavit that said I got 61,000. The contractor that got 6,000 wasn't.
Sperber, what I'm hearing from you is you disagree still with the judge's factual findings. That's it.
I disagree.
Because what the appellate term said was, no, there was no fraud. So instead of reconstructing the whole thing, you only get the look back with respect to the damages. You're saying that wasn't enough. The appellate term should have also said, and the judge's factual findings were wrong. Is that it?
Yes, Judge, you said it much better than I said it. And the reason for that is because each of the items that we spoke about are permitted, and we cite the cases why they're all permitted.
All right.
Okay. Why don't we hear from Mr. Price? We've gone way over time on this one.
Good afternoon, Justice Acosta, Justices of the Appellate Division. If it pleases the court, my name is Joshua Price. I represent the respondent tenants. Justice Acosta, may I be heard?
Yes, you may. Good to see you too, Mr. Price. It's been a while.
Thank you, Judge. It's been a long time. I hope everybody's happy and healthy.
Thank you.
As usual, you prepare for argument, you plan to say certain things, but as the respondent, I listened to the questions. I heard my friend, Mr. Sperber. So I'm just going to say a couple of things real quick. First, as far as the money is concerned, the dollars are concerned, the landlord contended that it spent $67,340. In order to deregulate the apartment, they needed to have spent $53,000 and change. Judge Elsner, after trial, and then after a motion J&OV and a cross motion J&OV, found that they spent $37,040. And in that second decision, because the law had changed, Judge Elsner said that she found it to be fraudulent. The appellate term said that it wasn't. Our position, very plainly, is this. And Judge Renwick, when I was sort of practicing with my colleagues, I think I said exactly what you just said, that I was struggling to understand Mr. Sperber's argument, because I don't understand how one could argue that you couldn't go back more than 4 years simply to determine regulatory status.
Right.
So, Justice Moulton, you're right. We did not cross appeal. It's our position that the determination of Judge Elsner the first time, the second time, and the appellate term that the apartment was improperly deregulated and is a rent-stabilized apartment cannot be disturbed on this appeal by Mr. Sperber saying that it went beyond the 4-year statute of limitations. I don't think that Mr. Sperber was arguing in his brief in any meaningful way that Judge Elsner just got the facts wrong. But as Mr. Sperber said, the parties decided to enter into the stipulated set of facts in lieu of trial and then brief the issues. For Mr. Sperber to now tell you, well, I brought the contractor, but we decided to do a stipulation instead, as though that would somehow persuade you that had the contractor actually testified, he would have better been able to show that money was spent, that Judge Elsner said that it wasn't. I don't know. I think it's a little late for that argument. And by the way, Judge Elsner determining and disallowing many of the alleged improvements that the landlord claimed, to go from 67,000 claimed to 37,000 found to be suitable, that's a lot. That's a lot. It's not as though the landlord just missed this by a couple of $1,000s because something got disallowed. This is $30,000 plus. And I think that the court should just take note of that, to the extent Mr. Sperber is arguing that we should have never gone back to fight over regulatory status. So where does that leave us? Assuming that the appellate division is going to affirm the 3 decisions that came first, saying that the apartment is deregulated, leaving us only with the overcharge portion of it. I agree. We're limited to damages to the 4 years back. So there's a base rent. We say this in our brief. We go back to what the tenants were paying 4 years prior to first imposing the overcharge claim, and then we calculate damages from there. The only question that I guess I have, and I understand you ask me questions, I don't ask you questions, but the only rhetorical question I guess I have is that the Rent Stabilization Code and the case law that comes from your court says that the landlord is entitled to what the rent was 4 years before, plus any lawful increases. Well, in this situation, the landlord didn't register the apartment, didn't offer renewal leases in the manner that the Rent Stabilization Code requires, that DHCR requires. I'm not sure how one figures out what the landlord was entitled to collect over the next 4 years above the rent on the base date, given that the landlord didn't do what it was supposed to do, that the tenant didn't have the opportunity to choose a 1-year renewal or a 2-year renewal where the rents would have been different. But having said all of that, the regulatory status should not be disturbed on this appeal. The amount of the overcharge should be limited to the 4 years immediately prior to the imposition of the claim. And then finally, Judge Elsner found that the tenants were entitled to treble damages. That hasn't been disturbed on her second decision or by the appellate term. To the extent that that's before you, while it will be a much smaller amount than it was before Judge Elsner, the tenants still are entitled to treble damages. And then finally, I saw that on Tuesday, the appellate division released a decision in a case called 305 Riverside Drive, where the facts seem to be very similar to this one. I was having a little trouble reconciling something in the beginning of the decision and the end of it, and I'm certainly not going to tell you something about your case that you obviously know better than me. But in that case, you found that the regulatory status was correct. You reduced and or eliminated the amount of the overcharge by sending it back, and found that the tenant was entitled to legal fees because the issue of regulatory status had been litigated all the way up to the appellate division. And since the tenant had prevailed on that issue, the tenant was the prevailing party and entitled to legal fees. Judge specifically found that we were entitled to legal fees. It was not disturbed on the JNOV motions. It was not disturbed by the appellate term. Mr. Sperber is asking you to undo that. If this court is going to leave our victory on the regulatory status in place, we are entitled to legal fees. And as a final thought on that issue, this is a holdover proceeding. The landlord sued the tenant to evict the tenant, saying, you are an unregulated tenant, your lease expired, you have no right to be here, get out. And sued to get a judgment and a warrant so that a marshal could come and throw them out. The finding up until now, and hopefully it will remain the same, is that it's a rent stabilized apartment and that they have the right to basically renew the lease in perpetuity subject to the Rent Stabilization Code. Whatever is the result on the overcharge claim, whether the tenants recover a lot of money, a little money, the tenants are very clearly the prevailing party because they'll be remaining in possession as rent stabilized tenants should the appellate division affirm.
Okay. Thank you, Mr. Price. You get 1 minute, Mr. Sperber.
Thank you, Judge. The question that I ask, and I guess, Justice Moulton, I hate to be asking it of you, but I believe you were on the Breen panel. In Breen, the appellate division said that neither the sizable increase based on the improvements nor the skepticism about the quality or extent of the improvements made a claim of fraud. In the instant case, all we have in the record is proof that the work was done. We have nothing in the record that says the work wasn't done. Now, when I was arguing, I think that Your Honors were inquiring as to whether or not those were disallowed improvements. But Mr. Price seemed to be taking the position that the import of Judge Ellison's decision is that she, without anything in the record, found that 67,000 should have been 37,000. And doesn't Breen tell us that that's not what we're supposed to do? Thank you.
Okay, thank you. Thank you both. And
Have a good afternoon.
Good afternoon. It's good to see you both. This concludes oral arguments for January 5th, 2022. Have a good night.
Have a good night.